Good morning and welcome to the Public Service Commission of South Carolina. It is Wednesday, December 13th at 9:31 a.m. and we are here to resume the hearing in docket numbers 2022-239-E and 2022-240-E. This hearing concerns the application of Duke Energy Carolinas LLC and Duke Energy Progress for determinations regarding balancing area competitive procurement of renewable energy framework and a possible approval of the 2022 solar procurement program. I think we have all parties. We have some virtually. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. And appearing virtually, we have Commissioner Irvin. Are there any preliminary matters from the parties before we begin with testimony from witnesses? Hearing none, recognize Mr. Welborn for the Duke companies.
Thank you, Madam Chair. Good morning, Madam Chair, Commissioners, Vice Chair Powers, Mr. Stark. The companies would first call Ms. Heather Shirley Smith, Mara Farber, and Mr. Glenn Snyder to the stand.
Thank you. Witnesses, please come forward and be sworn by the court reporter. Mr. Welborn, please proceed.
Thank you, Madam Chair. If it pleases the Chair, I'm going to start with Ms. Smith, and then I'm going to turn the other two panelists over to my co-counsel. Good morning, Ms. Smith. Would you please state your name for the record? And by whom are you employed and in what capacity?
Would you please turn your microphone on? Thank you.
Did I get it?
It's on.
Okay. Do we need to start over?
Ms. Smith, please state your name for the record.
Heather Shirley Smith.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Corporation, and I'm Vice President of Regulatory Affairs and Policy for South Carolina.
And did you prepare or cause to be prepared 22 pages of second amended direct testimony that were pre-filed with the Commission in this proceeding on December 8th, 2023?
Yes.
Do you have any changes to that pre-filed testimony at this time?
I do not.
If I were to ask you the same questions that were contained within your pre-filed testimony, would your answers remain the same?
Yes.
Chair Belser, I would ask that Mrs. Smith's pre-filed second amended direct testimony be entered into the record as if given orally from the stand.
Ms. Smith's second amended direct testimony will be received into the record as if given from the stand. Ms. Smith, I know you've got a notebook. I need for you to talk into that microphone as much as you can. I know you want to look at your lawyer, but look at the mic if you don't mind.
I'll do better.
Thank you, ma'am.
Thank you, Madam Chair. Ms. Smith, did you also prepare or cause to be prepared one publicly filed exhibit that was attached to your pre-filed second amended direct testimony?
Yes.
Do you have any changes to that exhibit at this time?
I do not.
Chair Belser, I would ask that Ms. Smith's publicly filed exhibit accompanying her direct testimony be entered into the record as the next hearing exhibit.
I think that's labeled Exhibit 1 to
That's
her.
right.
Okay. Exhibit 1 that accompanied Ms. Smith's second amended direct testimony will be marked for identification as hearing Exhibit number 2 and received into the evidence of this case. Confidential designation was previously awarded or afforded, I believe. Was it not? Or no?
I don't recall that exhibit being
Okay,
confidentially
we will.
filed.
Well, you said it was public.
That's right. It's public. There was no confidential.
Okay, I
analog.
apologize. I thought I had confidential of something. That's Ms. Farber, excuse me.
That's right. That's right.
Okay. Marked as not confidential, marked for identification as hearing Exhibit 2 and received into the evidence of this case.
Thank you, Chair Belser. Turning to your rebuttal testimony, Ms. Smith, did you prepare or cause to be prepared 26 pages of amended rebuttal testimony that was pre-filed with the Commission in this proceeding on December 8th, 2023?
Yes.
Do you have any changes to that amended rebuttal testimony at this time?
I do not.
If I were to ask you the same questions that were contained within your amended rebuttal testimony this morning, would your answers be the same?
Yes.
Chair Belzer would ask that Ms. Smith's pre-filed amended rebuttal testimony be entered into the record as if given orally from the stand.
Ms. Smith's amended rebuttal testimony will be entered into the record as if given from the stand.
Thank you. Turning to your supplemental testimony, Ms. Smith, did you prepare or cause to be prepared 22 pages of amended supplemental testimony that were pre-filed with the Commission in this proceeding on December 8th?
Yes.
Do you have any changes to your pre-filed amended supplemental testimony at this time?
No.
If I were to ask you the same questions that were contained within your pre-filed amended supplemental testimony, would your answers remain the same?
Yes.
Chair Belzer, I would ask that Ms. Smith's pre-filed amended supplemental testimony be entered into the record as if given orally from the stand.
Ms. Smith's amended supplemental testimony will be entered into the record as if given from the stand.
Thank you. And I appreciate the Chair's and the Commission's indulgence as we go through this. I know there were different rounds of testimony. Turning to your supplemental rebuttal testimony, Ms. Smith, did you prepare or cause to be prepared 25 pages of supplemental rebuttal testimony that were pre-filed with the Commission in this proceeding on November 1st?
Yes.
And do you have any changes to that supplemental rebuttal testimony?
I do not.
If I were to ask you the same questions that were contained within your pre-filed supplemental that were asked in your pre-filed amended rebuttal testimony, would your answers remain the same?
Yes.
Chair Belzer, I would ask that Ms. Smith's pre-filed supplemental rebuttal, shall I do that one again?
No, but you used amended before you got to this part, and that's what was throwing me.
We did not amend her supplemental rebuttal
don't think
testimony.
so.
Why don't I do that one again, if it's all right with you? Thank you. Ms. Smith, do you have any changes to your supplemental rebuttal testimony at this time?
No.
And if I asked you the same questions that were contained within your supplemental rebuttal testimony, would your answers remain the same?
Yes.
Thank you, Ms. Smith. Chair Belzer, I would ask that Ms. Smith's pre-filed supplemental rebuttal testimony be entered into the record as if given orally from the stand.
Ms. Smith's supplemental rebuttal testimony will be entered into the record as if given from the stand.
Thank you, Madam Chair. And Ms. Smith, did you prepare or cause to be prepared 5 pages of settlement testimony that were pre-filed with the Commission on December 8th?
Yes.
Do you have any changes to your settlement testimony at this time?
No.
If I were to ask you the same questions that were contained within your pre-filed settlement testimony, would your answers be the same?
Yes.
Chair Belzer, I would ask that Ms. Smith's pre-filed settlement testimony be entered into the record as if given orally from the stand.
Ms. Smith's pre-filed settlement testimony will be entered into the record as if given from the stand.
Thank you, Madam Chair. And Ms. Smith, did you prepare a summary of your pre-filed testimony?
I did.
Please present your testimony summary to the Commission.
Sure. And good morning. The purpose of my direct and rebuttal testimonies is to support the company's 2022 solar procurement program as the company's balancing authority area-wide competitive procurement of renewable energy program under South Carolina Code 584120E2. My pre-filed direct testimony addressed the components of the company's 2022 RFP for new solar resources in response to Commission Order 2022-482 and explains how the company's ongoing implementation of this existing CPRE program is good for the company's customers in South Carolina and aligns with the company's Commission-approved IRPs. My pre-filed direct testimony explained that we were seeking 1,200 megawatts of solar resources with a reasonable balance of utility-owned and third-party-owned projects, along with a description of how the projects being sought could be located anywhere in our balancing area, which covers service territory in both South Carolina and North Carolina. My direct testimony also described our stakeholder engagement and our plans to use an independent evaluator for the 2022 RFP. My direct testimony also sought guidance on how the Commission wishes us to handle future RFPs. My rebuttal testimony responded to certain arguments made in testimony from ORS and explains that the company's application, in accordance with Act 62, sought approval of a reasonable and well-designed CPRE program within the company's balancing authority areas to procure solar resources already identified in the company's most recently approved resource plans. Like my pre-filed direct testimonies, my pre-filed supplemental direct and supplemental rebuttal testimonies also supported a commission finding and approval of the 2022 RFP as being in the public interest. My testimony also acknowledged the Commission's finding that where a utility's IRP identifies a specific need or benefit from adding renewable energy, a CPRE program can provide a cost and time-efficient choice of procurement. My supplemental direct testimony explained that the companies procured 965 megawatts of new solar resources, including 8 of 15 winning projects cited in South Carolina, and discussed how the independent evaluators' post-RFP report indicated that the bidding process was appropriately conducted. I also explained why a balanced RFP procurement of utility-owned and third-party resources is a reasonable process and included in our procurement framework, and why I believe that it's appropriate for the Commission to find and approve our proposals as being in the public interest for South Carolina. My supplemental testimony also explained how the 2022 RFP will help efficiently deliver renewable energy to South Carolina customers. My supplemental rebuttal testimony responds to ORS Witness Hip's supplemental direct testimony and explained my belief that the Commission received all the necessary information to find that the company's CPRE framework and the 2022 RFP to be in the public interest. Since the filing of all of that testimony, all parties have reached a comprehensive settlement agreement, and my settlement testimony supports that agreement. On behalf of the companies, I recommend and request that the Commission approve the proposed settlement agreement because it represents a just and reasonable resolution of the issues in this proceeding and acknowledges that the company's use of their existing single system-wide procurement framework and processes as described in our application is a prudent and efficient approach to the procurement of renewable resources in accordance with South Carolina Code 584120E2. Also, the settlement agreement supports that the 2022 RFP resulted in a fair, open, transparent, and non-discriminatory procurement. And 3, that the 22 RFP is a reasonable step for the companies to take toward procuring renewable
Chair.
Good morning, Mr. Brightworth.
Good morning, Madam Chair. Good morning, Commissioners. Hope you're all well. Good morning, Ms. Farber.
Good morning.
Would you please state your full name for the record?
My name is Maura Farver.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy, and my title is State Energy Policy Director.
Thank you. And Ms. Farber, did you prepare or cause to be prepared 35 pages of direct testimony that was pre-filed with the Commission on January 17th of this year?
Yes.
And do you have any changes to or corrections to that direct testimony at this time?
No.
And if I were to ask you the same questions today that were presented in your pre-filed direct testimony, would your answers be the same?
Yes.
Thank you. Chair Belcher, at this time I'd ask Ms. Farver's pre-filed direct testimony be entered into the record as if given orally from the stand.
Ms. Farver's pre-filed direct testimony will be entered into the record as if given from the stand.
Thank you. And in support of that direct testimony, Ms. Farver, did you also prepare or cause to be prepared two publicly filed exhibits?
Yes, I sponsored those exhibits in support of my testimony.
Thank you. And do you have any changes to those exhibits at this time?
No.
And Chair Belcher, I'd ask that Ms. Farver's two direct exhibits be entered in the record as the next composite hearing exhibit. And there was no confidential information, just public for the direct exhibits.
Thank you. Ms. Farver's exhibits which accompanied her pre-filed direct testimony and are marked Exhibit M Farber Exhibit 1 and M Farber Exhibit 2 will be a composite exhibit marked for identification as hearing exhibit number 3 and admitted into the evidence of this case.
Thank you, Chair Belcher. Ms. Farber, now turning to your rebuttal testimony, did you prepare or cause to be prepared 9 pages of rebuttal testimony that were pre-filed with the Commission on March 6th of this year?
Yes.
And do you have any changes or corrections to that rebuttal testimony at this time?
No, I do not.
And if I were to ask you the same questions that are identified in your rebuttal testimony today, would your answers be the same?
Yes.
Thank you. Chair Belser, at this time, I'd ask that Ms. Farver's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Ms. Farver's pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Thank you. Turning now to Ms. Farver's supplemental testimony, did you prepare or cause to be prepared 6 pages of supplemental testimony that was pre-filed with the Commission on August 18th of this year?
Yes.
And do you have any changes or corrections to that testimony at this time?
No.
And if I were to ask you the same questions again today, would your answers be the same?
Yes.
Chair Belser, turning to Ms. Farver's supplemental testimony, would be asked that be entered into the record as if given orally from the stand.
Ms. Farver's supplemental testimony will be entered into the record as if given from the stand.
Thank you. And Ms. Farver, did you prepare one confidential exhibit that was filed under seal in support of that supplemental testimony?
Yes.
And do you have any changes to that exhibit this time?
No.
Chair Belser, I would ask that Ms. Farver's one confidential supplemental exhibit be entered in the record as the next composite hearing exhibit, and that it remain under seal as pre-filed.
Ms. Farver's exhibit that accompanied her supplemental testimony marked as M. Farver Supplemental Exhibit 1 will be marked for identification as Hearing Exhibit 4 and admitted into the evidence of this case. The confidential version will remain under seal.
Thank you. Ms. Farver, did you prepare a summary of your pre-filed testimonies to present to the Commission today?
Yes.
Would you do so at this time, please?
Yes. The purpose of my direct and rebuttal testimonies is to provide an overview of the company's 2022 solar procurement program, the 2022 RFP. My direct testimony provides an overview of the 2022 RFP and discusses how the company's system-wide framework is designed to select the highest-ranked, lowest-cost, utility-owned, and third-party-owned controllable PPA resources that are expected to come online between 2025 and 2027, targeting 1,200 megawatts system-wide. My rebuttal testimony acknowledges the parties' agreement that there are benefits to a well-designed competitive procurement of renewable energy, or CPRE, program, the parties' support for the framework of the 2022 RFP, and how the company's 2022 RFP meets ORS's recommendations for independent oversight and utilizing a well-designed RFP process. The purpose of my supplemental direct testimony is to present the results of the 2022 RFP and the post-solicitation report prepared by independent evaluator Charles River Associates, Incorporated. The 2022 RFP procured a reasonable mix of utility-owned and controllable PPA projects totaling 965 megawatts. This is inclusive of 622 megawatts of PPA projects and 342.5 megawatts of utility ownership tract projects. 8 of the 15 projects selected, totaling approximately 460 megawatts, will be sited in South Carolina. The 2022 RFP independent evaluator confirmed that the selected resources represent the highest-ranked portfolio of options that minimize long-term costs and risks for the company's retail customers. Specifically, the IE's report stated that Duke's 2022 RFP was highly competitive based on our experience in administering capacity RFP processes for utility clients. And the 2022 RFP process was conducted in a fair, transparent, open, and non-discriminatory manner. No proposals were given any undue advantage, and the selected resources represent the highest-ranked portfolio of options that minimize long-term costs and risks for the company's retail customers. Since the filing of my testimony, all parties have reached a comprehensive settlement agreement. I support the settlement agreement and believe it represents a just and reasonable resolution of the issues in this proceeding.
Thank you, Ms. Farver. Turning now to Mr. Snyder. Good morning, Mr. Snyder.
Good morning.
Would you please state your full name for the record?
Yes, my name is Glenn Snyder.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy as Managing Director of Integrated Resource Planning and Analytics.
And Mr. Snyder, did you prepare or cause to be prepared 14 pages of supplemental rebuttal testimony that was pre-filed with the Commission on November 1 of this year?
Yes.
And Mr. Snyder, is that the shortest piece of testimony that you've ever filed with this Commission?
Yes, it is.
Thank you. And do you have any changes to your supplemental rebuttal testimony at this time?
No, I do not.
And if I were to ask you the same questions today that were asked in your pre-filed supplemental rebuttal testimony, would your answers be the same?
Yes, they would.
Thank you. Chair Belser, I'd ask that Mr. Snyder's pre-filed supplemental rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Snyder's supplemental rebuttal testimony as pre-filed will be entered into the record as if given from the stand.
Thank you. Mr. Snyder, did you prepare a summary of your pre-filed testimony to present to the Commission today?
Yes, I did.
Would you please provide that summary at this time?
Yes. Good morning, Chair Belser, Commissioners. Good to be with you this morning. The purpose of my supplemental rebuttal testimony is to respond to certain arguments contained in the testimony of ORS and CCEBA. In response to those testimonies, my supplemental rebuttal testimony explains that the 2022 solar procurement, or 2022 RFP, is consistent with the company's most recent Commission-approved integrated resource plans, which identify a need for significant amounts of solar generation to be added to the company's system. My testimony also explains that the companies need the Commission to affirm that the company's plans to bring on new solar generation are reasonable and in the public interest for South Carolina. I also explained that the 2022 RFP takes a balanced approach to ownership of solar resources and that the company's approach is both reasonable and in the best interest of the customers in South Carolina. Since the filing of my testimony, all parties have reached a comprehensive settlement agreement. I support the settlement agreement and believe it represents a just and reasonable resolution of the issues in this proceeding.
Thank you, Mr. Snyder. Chair Belser, pursuant to the comprehensive settlement agreement filed with the Commission, all parties have waived cross-examination, so the panel is now available for questions from the Commission.
Thank you. Commissioners, questions for the panel. Commissioner Carolee Williams.
Thank you, Chair Belser. Good morning. We get to do this little dance, particularly with Ms. Favre. Cindy, you're good? No. Right now, it's just tricky to get my voice heard and be able to see you all as I ask. My questions are really for any of the three of you, so I'll let you decide who can best answer it. But thank you in advance. Please kind of reiterate, explain why a ruling on the RFP framework is that it's sufficient and within keeping in the statute.
I'll welcome any of my panelists to also address this, but Act 62 gave direction on competitive procurement of renewable energy programs, which is of course what we filed. The Commission issued an order some time ago looking at some key factors of the framework and what the parties or utilities should be considering when they put competitive procurement renewable energy programs together. And so when we look at the balance of all of that information as well as what we've actually conducted in our program and RFP, we think all the key elements are there. I would think first and foremost, the use of an independent evaluator. It's one thing to have an RFP, it's another thing to execute and evaluate and make sure it was done according to its terms and in a fair and non-discriminatory manner. And we have provided that information and utilized that process. That's also in keeping with FERC best practices. Our framework also includes the entirety of our balancing areas in North and South Carolina, and that is extremely important and helpful for customers. And the reason is we have over 50,000 square miles of service territory to site these resources in. And when you look at that opportunity, and when you look at developers in both states who can submit bids, and when you look at the geographical diversity and the locational opportunities to compete and get the best sites for the best prices for the best projects, that ability to leverage the balancing areas is very important for our customers and is really a tenet of our system. We also had a very open stakeholder process, including developers and a variety of other participants. We also filed information on that with the commission, so if we didn't catch everyone who might be interested, that there would be additional information for folks to lean into. And so our RFP followed a stakeholder-informed process. We also, see a clear link in terms of how our IRP plans have influenced our RFP. So our RFP is consistent with volumes deemed to be necessary and part of the resource plan in our last filing. So we're within the bounds of the amount of solar resources that we're providing. And this is a key piece of our all-of-the-above energy strategy. So we're moving toward a variety of different energy sources. Our IRPs have identified renewables, and solar in particular, as an important component of that entire portfolio. And we believe that this is a reasonable way to go about it. We also have a number of features within the RFP that provide customers benefit, including some price adjustments that allowed bidders to take advantage of any tax benefits that may have happened during the course of the bidding process. And we also align the procurement with our interconnection processes. So it's really an entire system where we have an annual cluster going through the interconnection process, and all of the procurement is tied to that process for maximum efficiency for our customers, for the bidders, and to make sure that we have the right resources coming online. And then finally, we think there's some benefit in doing it once. So these are intensive and laborious processes, and the fact that we're able to gather such a large amount of bidders over the balance of our territory and do that in one administrative push, doing it one time, we think that's beneficial and within the keeping of the reference of balancing areas in Act 62. I'm sure I left some good stuff out, and I'll welcome my fellow panelists to also supplement my answer or correct it.
No, I think you hit on most of the salient points. And again, just reiterate, consistent with our most recently filed as well as our previous IRPs in terms of the need for solar that was identified in those IRPs, and consistent with Act 62's IRP directives seeking a diverse array of resources as part of our integrated resource plan.
Mr. Snyder, would you go into a little bit more detail in terms of the consistency with the 2022 IRP?
Yes. The 2022 IRP, we called for a mix of resources, natural gas, solar, batteries, etc. And the solar that's contained within this RFP is an execution step that has volumes that are generally consistent with those that were identified in the most recent approved IRP. We even have more solar now in the most recently filed but yet to be litigated IRP. So, we have to recognize that these IRPs are a snapshot in time, and that those needs change over time as we file IRP updates or new comprehensive IRPs. And so we see these volumes consistent with both historic and ongoing needs for solar. And it's a part of our execution plan that is going to be required to be pretty dynamic as we see this need growing over time.
That was a really full answer, and so I'm going to kind of check my notes to see how many questions I have left, given the volume of what you gave me. So I'm going to close my questions for the minute and pass it on to one of my other colleagues. Thank you, Chair Belser.
Commissioner Caston.
Thank you, Madam Chair. And good morning, ladies and gentlemen.
Morning.
Morning.
Mr. Snyder, my ears didn't hear fast enough. Did you, in response to Commissioner Carolee Williams' question, did you say 2022 IRP or 2022 RFP?
The acronyms are very close.
Yes, they
and
are.
when you speak fast, I've had that same question myself. So I was saying our IRP, Integrated Resource Plan, that we submitted in 22, our 22 update,
Okay.
called for significant amounts of solar that are consistent with this RFP, and that the 23 comprehensive that we recently filed shows an even increased amount of solar need. So, depending on when you snap that chalk line in time, that this RFP, request for proposal, the volumes outlined in that RFP are consistent with our IRP submittals with this commission.
Well, I guess that kind of answered my question, because I didn't know if you were talking about the 2020 modified RFP, the 2022 update, and if you remembered what those quantities were, because I kind of did, and I went back, and looked at the modified. But so, am I understanding you to say what Duke has proposed in their 2022 RFP? The quantities are in line or match the 2022 IRP update?
Yes, sir.
Thank you.
You're welcome.
Relative to the PPAs, the duration, the lease duration dates, do you recall what those were in the IRP relative to South Carolina versus what you have in the proposed RFP? We really need to use some different acronyms.
Agreed. I don't know if there was you take that contract.
If the question is on the duration of I believe, and subject to Ms. Farber correcting me, that the procurement sought 25-year PPAs. In the context of an integrated resource plan, we look at the entirety of the life of the asset, which is generally 35 years for solar. And so whether that's in a levelized PPA structure or whether that's in a utility rate-based structure, we tend to model those as 35-year assets, irrespective of the PPA tenor that is suggested. Now, once we enter into PPAs, those become existing resources within the portfolio, and those are represented over the life of the PPA, and then they become what we call undesignated, or they're a need that's identified at the expiry of those PPAs. We show those as undesignated, yet to be procured resources. But for modeling purposes, we look at the economic benefits and costs of resources over the useful life of the asset, which for solar is 35 years.
For modeling.
For modeling.
Okay, let me drill down on that a little bit if I could, because in the, I guess Ms. Farber, well, it'd be the panel, but that's what I was reading, I think, on page 4 of Supplemental Exhibit 1, first paragraph, where talks about utility-owned solar cost at a 30-year dollar per megawatt hour basis and third-party PPA on a 25-year dollar per megawatt basis. And I was just trying to understand all that, like as far as the PPA upper limit in South Carolina, you know, what that number is and how it relates to this. Where did 30 and 25 come from, if someone could elaborate on that?
Sure, I can speak to that a bit. The 25-year term of the PPA was actually something that was discussed in the stakeholder meetings. And so our prior procurements had a 20-year PPA, and the decision was made to move to a 25-year PPA with support of stakeholders and the independent evaluator. For a utility-owned asset, of course, we own that asset for the entire life of the asset. And so the life of the asset has, the assumption of the life of the asset has changed over time as the technology has developed and improved. And so I believe, you know, several years ago, the assumption of the life of the asset was closer to 25 years. But now with today's technology, we're seeing assets that can extend to 30, 35 years. And so the assumption for the utility ownership track resources was that they would be a 30-year asset.
Okay, but I guess what I'm trying to make sure, like whether in the stakeholder discussions and everything else, when you have those discussions and you're looking at that kind of stuff, do you also consider, okay, is the South Carolina regulation or law different? Is it the same? Is it more? Is it less? Is that considered?
Yeah, I'll be happy to take that one. So the competitive procurement piece of code is in the overall avoided cost statute. And so it's an additional way to procure solar. And so you have traditional QF contracts that are conducted under PURPA for avoided costs, but you are also allowed to do competitive procurements rather than an administratively set price by the commission. And so that's an alternative, and that's why that's in that piece of code, in my belief. And so in addition to that, the piece of code about competitive procurement gives the commission wide discretion and allows us a lot of options in coming up with the best program that's going to solicit the most bids so that we can have a process that leads to competitive prices. So, so South Carolina, you know, requirements for a CPRE are very broad, and a lot was left up to this commission in determining what was appropriate.
All right, so I want to make sure I understand all that. If our upper limit in South Carolina is 20 years for PPA, are you saying that the CPRE portion in the statute allows the company to make that 25, 30, or whatever it wants to be, not what the existing
Exactly. You're exactly right, because it's a different way to go. That's our position. Yes. Yes.
Not necessarily ours, but Duke's.
Yes.
Okay.
If I may, I can also add a distinction between sort of the standard or negotiated contracts that we commonly think of when we think of PURPA QFs. This procurement was an alternative PURPA in that it also has dispatch and control rights. And so we have economic curtailment rights for these resources that we are not allowed in those standard and the negotiated contracts. So there's sort of enhancements to these 25-year contracts.
And one other, I think, important distinction is these contracts also come with the conveyance of all environmental attributes, which when you think about a 25-year contract, whether customers within would like those attributes, we now have those conveyed to the company, where a standard PURPA does not. If there's future regulations at the state or federal level that require those attributes to be in compliance, we would own those attributes under this procurement, where we would not under a typical PURPA. contract, and so that has benefits both today and in the future potentially for the customers of South Carolina as they now would own those environmental attributes in a way that they wouldn't with a standard PURPA contract.
Do you want me to continue? Give me a couple more and I'll take a pause here. In that same, I think it was the same paragraph. Let's see, where was that? No, it was on page 6 of 23 of Ms. Farber, of your exhibit. We talk about the carbon plan solar reference cost was determined by taking the 55%, 45% weighted average of the levelized utility-owned solar cost. Where does the 55-45 come from? How was that derived?
So for this procurement, we were seeking a balanced portfolio of resources and having a healthy mix of both types. And so there are different benefits and risks associated with PPAs versus utility-owned projects. And so we wanted to ensure that customers were, in a sense, diversifying their portfolio by having a balanced mix of each. Today's current mix on the system is closer to 95% PPA and 5% utility-owned. And so by having this slightly skewed percentage, we'll slowly move in the direction of a more balanced portfolio overall.
I would say that the 55-45 split is codified in North Carolina law. So, and we think that's a reasonable balance. We've been talking about ownership for a while since Act 62 was enacted. So it's codified in North Carolina law, and in my role in looking at it through a South Carolina lens, it was consistent and reasonable, a reasonable balance. So I hope that directly answers your question.
But it's not codified that way in South Carolina law.
There's no codification of any split in South Carolina. There are directions to the company in the IRP when planning its system to balance things like not just cost, but reliability, risk, diversity of supply. And so I also think that the balanced approach that we have to ownership hits on some of those aspects as well.
Can I follow up on this?
Yes, please.
55-45 split? Isn't that also the section in North Carolina that talks about the ownership requirements shall be applicable to solar energy facilities paired with energy storage and procured in connection with any voluntary customer program? Isn't that
Subject
language
to check.
Also in that?
I believe so, subject to check.
Well, okay, so is that 55-45 split, does there have to be battery storage? And I reckon I'm curious as to that language of voluntary customer program. Is that the solar field, or is that a voluntary customer program? Is that like residential rooftop or behind the meter rooftop or behind the meter solar?
I believe this applies to what we call utility scale. So I don't believe that pertains to behind the meter solar resources, but a program such as Green Source Advantage on a forward-looking basis, the target would be 45-55.
And I would add, Chair Belser, that whether it's paired or not paired, I think the intent was either way, the 45-55 applies to standalone solar or solar that is paired. It does not have to be paired, I think was part of your question. So either standalone or paired, and it would apply to.
And I think coming back to South Carolina code and South Carolina requirements, of course, nothing in the reference that you mentioned, Chair Belser, binds
Appears in South Carolina.
Yeah, or binds South Carolina.
I'm aware of that, and thank you for that clarification. But I know that this is a standard in North Carolina law, and I'm just trying to understand how that got to that point up there. I'm just wanting to understand it. I'm not trying to. dispute it, but I just am trying to understand that. Okay.
I mean, I wasn't involved in the legislative process in North Carolina. Now, I do know that in our 2023 RFP, which is ongoing and not a subject of this proceeding, we do have solar paired with storage in that RFP. And so I don't think any of us was directly involved with the legislative
And that's
process.
fine. I reckon that I'm also curious as to the term, and I understand that y'all may not have been there, but y'all are dealing with, well, Ms. Smith, you're kind of in South Carolina, so I'm not sure that you're dealing with it as much, but procured in connection with any voluntary customer program. That's not utility scale solar, though, is it?
Yeah.
It
Yes.
could be.
Voluntary customer?
Yes, in South Carolina, we have a voluntary renewable energy program statute, and that's GSA, the Green Source Advantage Program, which is a program by which a customer, like an industrial customer, can negotiate directly with a third-party supplier. And so we do have voluntary programs like that in South Carolina, as well as other programs that we've proposed to the commission.
Okay. I just hadn't thought of it in that regard, and I appreciate that clarification. Thank you. Thank you, Commissioner Caston.
Certainly. May I continue, Caroline? In these stakeholder meetings that you have, I guess when you're discussing different things, and I got to be honest, I don't know who all's represented as far as percentages, you know, in South Carolina, North Carolina, and such as that. Are the discussions in these stakeholder meetings, do you consider, does this comply with South Carolina law? Does this comply with North Carolina law? Do you consider those things?
Certainly, I can speak to that. In our stakeholder meetings, we often started off with sort of an update on both the South Carolina and North Carolina regulatory framework. And there were stakeholder participants across both states. This was an open and public meeting. ORS was invited, and I believe witness HIP's testimony says they attended when available. We had CCBA, one of the interveners here, as an active participant in our stakeholder meetings. Southern Current is certainly an active participant in our meetings. So there's certainly plenty of South Carolina representation in our stakeholder discussions.
Okay, good. Let me ask this. In your document, I'm trying to remember where, you state resources selected through the RFP process will serve customers' future needs as a part of the company's 2022 carbon plan filed in North Carolina and support Duke Energy's integrated Carolina's energy transition. Does South Carolina have a carbon plan or carbon reduction goals?
No, we do not, although there is a lot in South Carolina code, in several pieces of code, I don't have the code with me, but in the energy office statute, there's some reference to looking at emissions. In the fuel statute, there is reference around reducing risk and diversity of resources. And of course, in the IRP, the mix of resources have a variety of factors, and those attributes are also considered. So we don't have a carbon plan in South Carolina, but we also have a lot of similar goals. We don't maybe have similar statutes, but the statutes in both states have a lot of commonality, although they're codified differently. But we do not have a carbon goal in South Carolina.
To your knowledge, does South Carolina law require that the Duke companies to implement an energy transition to take place with any specific time frame?
I think we do have that burden under South Carolina law, not in order to reach a certain level of carbon reduction, but in order to maximize and operate our system efficiently, being mindful of reliability and affordability and continuity. So I do think there is a clear expectation in South Carolina law that we will have an optimized system that looks at things like commodity price risk, reliability, and diversity of supply. So I think the interesting thing here is it's sort of a two things can be true principle, that there's an energy transition going on in both states. The motivators might be different.
Well, to your knowledge, is there any statute or regulation in South Carolina that would prioritize an energy transition above least cost to ratepayers and grid reliability?
Well, I think the energy transition is part of reliability and affordability as we look at it.
And maybe I would add, if you look at Act 62 in the IRP statute, it has a list of balancing factors. And clearly reliability and affordability are two of those factors, but as Ms. Smith just referenced, fuel diversity, diversity of resources, commodity price risk, you know, there are several balancing factors beyond just those two. So I think that's the where two things are true at the same time. It's codified differently, but many of the objectives of a reliable, efficient system that minimizes risk for customers is the same intent in the two states.
And I would just add, bringing it back to this 22 RFP and sort of the four corners of this docket, solar being fuel-free generation is one of the reasons it pops out in the IRP as being in customer interest. It's also something we're directed to look at in the fuel statute in terms of minimizing overall cost, and also having renewable energy that our IRPs have indicated is necessary for the system helps put downward pressure on fuel rates. And so as we add fuel-free generation to our mix, that puts downward pressure on the fuel volatility that y'all know as well as anyone, having seen those cases come before you.
Okay. Let me ask these last couple of questions, because I want to make sure we're on the same wavelength, or that I understand. Is it your understanding that the settlement agreement does not approve cost or proposed systems or amounts?
Correct.
Is it your understanding that any additional generation cost will be evaluated at the appropriate time and within South Carolina law?
Yes, sir.
I believe that's all I have. I will turn this back over to
Commissioner Carol Lee Williams.
Thank you, but I look to my other colleagues in case they want to. Okay, go ahead. Thank you. Ms. Shirley, Ms. Smith, you referenced a request that you made in your testimony regarding future RFP guidelines. Would you talk a little bit about that for me?
Sure. So we don't have a lot codified in South Carolina, as we've talked about in this proceeding, and we want to be helpful. We think it's important that the Commission have, and parties and ORS, but we think it's important that the Commission have an eye on what we're doing, when we're doing it, and how we're doing it. And so as we move forward through additional RFPs, we're in the middle of one right now, which is the 2023 RFP. We want to make sure that we're meeting the Commission's expectations about how and when to bring those in front of you. When I think of the 2023 RFP, which is underway, the timing of these annual cycles is consistent, so we'll have bids and an independent evaluator report along the same time frame as we had in this case. So whether the Commission wants us to come in at the tail end of that Given that it's already underway, we're happy to do that, happy to do it another way. And then as we look at RFPs that have not been issued yet, we're planning on following the same sort of stakeholder-informed process. And if there are South Carolina requirements or considerations from this commission that need to work their way into those RFPs or that need to work their way into the independent evaluators report, we want to make sure that we're meeting those expectations. It's a little different because it's not really codified. We haven't really gotten to that yet, and it's a unique type of situation. And so that's what we were requesting guidance on so that we move forward in full view of, in the commission's full view of how we're going about procuring solar that's indicated as necessary through our IRPs.
And do you have a recommendation?
I-
Based on what's worked for you all and what
Yeah.
hasn't been as smooth as you'd like it to be?
Sure. I don't have any agreement on this from anybody else, so this is not, there's
Okay.
people sitting behind me in the audience, and they might have their own view on that, in terms of the question, so I'm certainly only speaking for Duke Energy. I think for the 2023, it probably makes sense to come back, since it's already underway, it probably makes sense to come back and let you know how it turned out. And maybe around the August timeframe, we can provide the same information that we did this August. This is what the RFP called for. This is how it links to the IRP. This is how it turned out. This is what the independent evaluator said. I do think we have time if there's additional considerations for the independent evaluator to look at. That's I think. And then going forward in 2024, it may make sense, and I think this was in our original request. It's been a little while. I know we filed in September of 2022. I think we had maybe suggested maybe a generic docket or some sort of stakeholder process in front of the commission where parties could get together and think about what's the rational way to move forward where an RFP has not been developed or issued yet. So it's not our intention to leave South Carolina out of future RFPs. We just don't know exactly what y'all would like to do, and we're certainly open, and there'll be other voices in that, you know, not just Duke Energy, but that's an idea.
And what do you mean by where an RFP has not been issued? Do you
Like
kinda mean
2024.
in the future? Yeah.
Like 2024.
Okay. I know I have a couple more, so I'm just so let's go back to the conversation about North Carolina and South Carolina. As you're making decisions, are you thinking about recoverability from the South Carolina perspective and how to maximize benefits for South Carolina, or how to balance, what South Carolinians are paying for, what they're getting out of these processes, and how do you do that? Thinking about North Carolina, and the same question.
I'll take that first, and the first thing is that we look at what makes sense for our system, since our system spans both states. What makes sense for our system? What can we actually do? And then we pay a lot of attention to whether that makes sense for South Carolina. If there's code in North Carolina, doesn't automatically mean it's bad for South Carolina customers, doesn't mean it's good either. So we have to take a fresh eye and look at whether something makes sense for South Carolina customers or not, especially if there's no alternative code, or that can make things a little trickier. And so what we see in both this and going through time is two things can be true. Something can be good for customers, and it can be true that it's codified in North Carolina. It can be true that it may not be codified in South Carolina, and so that requires a deeper dive and looking at what's in the interest of South Carolina customers, which we believe the CPRE that we've proposed and that we've reached agreement on with other parties is.
Does anybody want to add to that? Because I imagine there might also be mathematical sort of evaluations that could be talked about, thinking about population, thinking about sites,
Maybe just to, and I always, Ms. Smith's gonna have my job soon because she hits the point so well, but, you know, it is a dual state system, and the fuel saving, we've always said this, and I think this commission's very aware, the electrons don't know what state they're in, right? And so the benefits of solar generation flow across the dual state system and reduce fuel costs for all customers in North and South Carolina. So when we look at the benefits, they accrue equally to the two states, right? So I talked about in my testimony that this is about 2,000 gigawatt hours or 2 million megawatt hours. That may not mean a lot, but that's about 1% of annual sales, about 2% of non-nuclear, if you think nuclear is half, right? And so this is about 2% that, but for this solar would be fossil generation. So you would need additional gas or coal to serve that load, and now you don't. And so those savings from the reduced fuel flow both to North and South Carolina. Those are modelable mathematical benefits, but then there's also the ones that are more difficult to model, which are, you know, as Ms. Smith pointed out, reduction in volatility of fuel prices as fuel can be constrained, especially during peak periods. And so relieving that volatility through solar procurement flows through equally to North and South Carolina customers. We have existing allocation methods where they share in those benefits. And I think it's just on a going forward basis, as we think about all resources having constraints. You know, I look across our entire portfolio, and we'll hear more about this probably in the upcoming IRP, is there's not an unlimited amount of any resource. There's not an unlimited amount of solar. There's not an unlimited amount of nuclear, not an unlimited amount of natural gas that can be added. And so as we seek this diverse portfolio of resources, those benefits flow across the system to both sets of customers in a manner that we think is proportionate based on the loads that are being served in both states.
It's a matter of opportunity as well, as we go down the path, and we have an all of the above energy plan. And so we're sitting here today talking about solar, but it's not to the exclusion of other resources. But specific to the RFP and specific to solar procurement, we also are informed by what our customers want and need. And so, when I look at this from a South Carolina lens, I think there's a lot of win-wins here. We get the benefits that Mr. Snyder just described in terms of lower fuel cost volatility from that fuel-free generation. Also in terms of system needs, having those kilowatts when we need them. But also we look at our customer interest. And we've had a lot of customers who want to have access to renewable energy. And so we've seen that as an increasing motivator. And so we've had a number of customers, I think they've even filed with this commission, wanting access to solar. And so we think this is a really good way to have a win-win. As we're procuring solar, sitting in my chair in Greenville, South Carolina, thinking about South Carolina companies, I want to make sure that we're able to harvest the RECs off of that solar and enable customers who need them, some of South Carolina's largest employers, to have access to those renewable attributes for their systems, for their sustainability purpose, and pay us for them, which helps pay down the cost of the assets. So we see a lot of win-win. That one's a little bit harder to quantify than the sort of the fuel case type calculations that Mr. Schneider was talking about. But we really are looking at it with a very wide lens and trying to meet the needs of South Carolina.
So, Ms. Smith, when you talk about customer demand, towards the end you were talking about commercial, industrial. Is that correct? Mm-hmm. Okay. And is that what you were primarily referencing?
Well, we have programs that are also proposed for residential customers. Right. Where residential customers who want to participate or support specifically renewable energy programs. And y'all will be hearing about this in the spring. but they also can have access to the renewable attributes of the system solar that we're procuring. So the electrons go to everyone, but in terms of being able to claim that slice and have the renewable attributes to go to it, that's something that's been increasingly important to our customers who have sustainability goals. The ones we hear a lot from in terms of quantity are the industrial and commercial customers, but we also have a lot of residential customers who are interested in participating in a variety of ways, and they have options through net metering. We do have a community solar program. It's full at the moment, and then we also have a proposal in the spring. But where we can line up that interest with something that's already been deemed to be good for and necessary for the system, that looks like a win-win for South Carolina to me.
I think I heard you say it's hard to quantify that interest. That would, in my mind, that would be very helpful just in general, not necessarily specifically for a decision here, but as everything matures, it would, I don't know what those metrics would be, but it would be interesting to have them based on your testimony that's part of your motivation.
Sure, we can actually give some more thought to that too.
Okay. There's been a lot of discussion about diversity and fuel cost and benefits. Are there also concerns about, as there's more solar put on the system, are there concerns that that's also being factored in?
I would say when Ms. Smith talks about the all of the above strategy, keeping a balance we think is important. You couldn't serve the system with all of any one particular resource. You do need this balance, and if you get out of balance, and that's pretty much what the IRP process is aimed at trying to articulate, is what is that proper balance. If you got too far out in front with any one particular, whether it's solar, whether it's wind, whether it's trying to do it all with gas and no renewables, you could run into some issues and risks for customers. But to put it in perspective again, we are talking here about 1% of total system energy, with bringing it back to the four corners of this procurement activity. And so I don't think we're broaching that point where the procurements we're looking at in the near term start to push us anywhere near the boundaries of having too much. So I would just offer that up.
You may have covered this before, but when you think about solar from the private perspective and the utility investments, from a cost perspective, how do you value those differently, or are they similar? You've got more control over one.
Sure. I can speak to that. So we do a levelized cost of energy analysis for both resources, but we understand that they're essentially different products. In part, the different term, we talked about the 25-year versus the life of the asset. There are a lot of qualities that don't translate exactly to that quantification. And so there are qualities that we assess in our non-economic scoring of the bids, and that is part of our overall ranking of the bids. But, and I think this is mentioned in the IE's report also, it's not a true apples-to-apples comparison to have the LCOE of PPA and the LCOE of UOT exactly match up. They just don't quite match.
I know what you meant, but could you spell that out? Because you're using acronyms. Level of cost.
Yes, the levelized cost of energy.
For PPAs versus?
The levelized cost of energy for utility ownership track.
Right.
Yeah, sorry about that.
There's also additional benefits of utility ownership. Both of these types of resources, whether third party or utility owned, carry their own unique benefits. And so I think some of the other benefits with utility owned is we continue to own the asset, whereas in a contractual situation, we don't. And when we think about life extension, I think about our nuclear plants, right? So we're looking at second life extensions on assets that we didn't think at the beginning were going to last this long. So we'll have those kinds of opportunities. For utility owned, we'll have also opportunities for technological advancements and also system sort of reconfiguration type stuff because we own and control them in that way. We do have controllability of the third-party assets too, but in the third-party assets, we also have benefits from displaced capital, that we're able to leverage capital for other system needs. Sometimes third parties are able to take advantage of different tax benefits in a way that we can't. There's also a different risk allocation, which is why we think a reasonable balance makes sense, so that way we get the benefits of both types of resources.
Thank you. I don't have many more, but thank you for your patience and your gusto in answering questions. You really hit on this earlier, but would any of you like to elaborate a little bit more on the kind of the benefits of solar when fuel costs escalate, as you mentioned, as we recently have all dealt with?
Yeah, I think, as we've said, I look at it as much like a hedge to fuel, right? And that's why you don't you want some of your fuel hedged. You've heard this in many of our fuel proceedings. I've sat through several, and our fuels team comes in and they talk about their fuel hedging program. And solar is effectively another tool in that toolbox for the fuel hedge. So they talk about their financial hedges or their physical hedges they put on the commodity itself. Solar is a unique opportunity to go out 25 years, right? So there's not as liquid of a 25-year fuel forward hedging market that they come talk to you about in the fuel cases, that you can garner that fuel hedge with a 25 or even longer 35-year or life extension beyond that. So it does provide that mix where you don't expose the entirety of your cost exposure for customers to the spot market. So you're reducing the amount of fuel that you need to purchase in a balanced manner.
Thank you very much. I appreciate the patience and your answers. No further questions.
Commissioner Justin Williams.
Thank you, Madam Chair. Panel, how are you all doing this morning?
Good, sir.
Just fine.
Doing well.
Ms. Smith, I got to tell you, as I was listening to your testimony, my mind just wandered back to, I think, one of the first times that you appeared before me when I was on the commission, and we spent a long time talking about Omaha steaks. Do you remember that?
I do. I tried to forget it, but it has stuck.
I want to give you all your flowers. I appreciate the level of preparedness that you brought today. Commissioner Williams said gusto. I just think you all are prepared to know what you're talking about, so I appreciate that. And I say that because if I ask you a question that you don't know the answer to, you can say, I don't know the answer, and I'll move on. So thank you for your level of preparation. I have one question. It may have been said, but I don't think I heard it. Was there any discussion about reliability and how your program will improve reliability in your system?
I can take that, or you can take that.
Everybody wants to take it, so there's the gusto coming forward. I think in terms of having, again, limits to all resources, one of the benefits of solar is it reduces dependence on other resources. And again, I think solar has the limits on how much you can add to the system, but so does gas, so does nuclear. There's limited number of sites. There's limitations on pipelines. There can be limitations during high demand periods on the commodity itself. And so whenever you introduce this balance that is called for in an integrated resource plan, you are helping to protect the customer from over-reliance on any one particular resource type. And so I think one of the benefits of the resiliency and reliability that solar provides is it reduces your dependence on other resource types like coal and gas, knowing that those are also important resources as part of your reliable mix. But not to be over-dependent on those is one of the benefits we see, especially as we've seen in past cases when those can become constrained at a point in time.
Yeah, I would add into sort of the concept of stretching your other fuel resources farther in periods of constraint. Solar has also been a big contributor to the system. So, of course, it's a huge contributor to the system at 3 o'clock on an August afternoon. But it's also important during the other months of the year to Duke Energy. When I think of Bad Creek and our pumped hydro storage being available in the wee hours of a cold morning, solar from the afternoon helps pump that up and make sure that we have that resource available. So the nature of the way that our assets work together is also a key component of reliability.
Ms. Smith is going to take my job.
That's all I have, Madam Chair. Thank you. Thank you to the panel as well.
Commissioner Thomas?
Thank you. So it seems like in the last 3 to 6 months or so, I read something about Duke was selling all of its renewable assets, let's say. Is that in process? Has it happened? What can you tell me about that?
That was our commercial arm of the business, and that sale has concluded, and the company made, the decision to focus on the regulated portfolio as we, go through this period of tremendous growth and focusing on our retail customers and our wholesale customers as well. But that was the commercial arm of the business. So that was a decision our holding company made, and in terms of where the time of our management is going to be spent and resources.
Yeah, just to be clear, because I see a little bit of, it's not part of the regulated utility. So that was a separate arm of the holding company that was doing business outside of our regulated utilities balancing authorities. And so that, as Ms. Smith just spoke about, was more of a holding company decision to focus on the regulated utilities and the needs of a very quickly growing regulated utility.
Okay, so basically it's outside the company's control now, and it was non-utility. I understand that. So is there potential that the utility will be entering into PPAs and buying power back from what was sold from those assets?
I can speak to that. In the 22 RFP, we did create a rule that no affiliates were allowed to participate in order to avoid any potential conflicts of interest or even appearance of conflicts of interest. So affiliates were not allowed to participate in the 2022 RFP.
But on a go-forward basis, these will not be affiliates, if I understand that correctly.
Sitting here today, this is subject to check. I'm not aware of any of those assets that were actually located inside the Carolinas territories. Those were that was a business line that my understanding was outside. We can do the subject to check, but outside of the Carolina service territory. So I for example, didn't interact with that side of the business. I think that's where I'd leave that.
Well, and the only reason that I was asking that is that would that increase the cost of if you're buying from what used to belong to the company?
Well, if the new business that owns that portion of what used to be part of the holding company if they were to bid into a future RFP, they would still have to prove that they're one of the least cost bids available. And so just by the nature of the evaluation process and the ranking process, they would have to be competitive.
All right, that's what I thought. Appreciate it. Thank you.
Great,
That's all I have.
thank you.
Vice Chair Powers.
Thank you, Madam Chair. Good morning, all, and appreciate you being here today. And I think you've been questioned pretty good so far. Ms. Farver, I want to go back to the apples
Sure.
compared to apples, because I think it's a pretty simple question as to project costs, whether it's owned by the utility or whether it's a PPA. I mean, the answer was, I tried to follow it, and maybe I just did not understand it because, I'm thinking it's either one or the other is cheaper, one or the other. Nobody put any numbers or anything that I could grasp in that answer. And I apologize if that's my fault.
No, not at all. So there is some confidential information about those prices that is included in the independent evaluator's report. I don't want to speak it out loud. I'm not sure about going into
don't do that.
confidential
Don't do that.
session or whatever. And so, if we want to get into the details of that, we can. But I was trying to explain that levelized cost of energy is looking at the energy that's produced over a certain time horizon. And so the time horizon for the PPAs is 25 years. The time horizon for the utility owned is 30 years. And so that inherently influences the calculation.
Okay. Well, one thing that popped to mind is that obviously if it's a utility-owned commodity as far as liability or cybersecurity, the company would be in a better position to certainly more qualified or technologically advanced to protect from that. That'd be a fair statement, wouldn't it?
Yes, I think so.
Okay. Ms. Smith, something that I think keeps my head spinning, and maybe I'm not the only one, is we're dealing with North Carolina and South Carolina. I know there's North Carolina law. We can't go by it. We cannot use it to make our decisions, and I know that's kind of hard on you and your company as far as making decisions and trying to keep the same things, keep the same standard, rather than having to do two different things in the same area. I know that's tough. It's kind of like sometimes go ask mama. If mama don't like it, go ask daddy, or just trying to meet that. What sort of internal discussions does Duke have to have when you're making decisions on things like this, as far as like the settlement agreement? What sort of internal decisions as to North Carolina law or do you have internal discussions about how to approach this?
I think it makes a difference if there's a fundamental difference in the rationale for why we are doing something, and does it meet customers' interests differently in either state. So just as South Carolina is not bound by North Carolina law, I don't think South Carolina is prohibited from supporting decisions that are in customers' interest just because something's codified in North Carolina law. And so when we look at it, particularly the chair that I'm in and the state president's organization that I work for, in terms of working for Mike Callahan, we look at whether something makes sense and is compliant with the law and policy of South Carolina law. And so when I look at the 22 RFP, it is within bounds and consistent with our latest IRP filings. It brings all the benefits that we talked about. It ensures that South Carolina gets a slice of that generation that we're bringing to the system. And so there's nothing in North Carolina law that changes those benefits and changes the need for those kilowatt hours to serve the system. So it kind of makes my head spin, honestly, too. And so that's one of the reasons in our pre-filed testimony we pulled back and concentrated on what is South Carolina law and policy. And I couldn't find anything that contradicted what we were trying to do and the benefit we were trying to bring customers.
Well, you know, I went to a doctor's appointment recently, and they start talking about a scale of 1 to 10. I said, you know, I can give you a number. What good does that do? And I guess that's why I didn't ask you that 1 to 10 as the difficulty. And I know in your comments earlier, you said that you're not involved in any sort of legislative activity in North Carolina, but I'm sure Duke certainly has their finger on the button there, and lobbyists and everything else to stay involved. We are definitely not involved in the legislative process here in South Carolina as commissioners, or even the commission itself. And we don't have a carbon policy. I mean, that's made clear. I just, it just concerns me that I don't want to read a bunch of North Carolina law, but it just concerns me that, you know, we're on track. And I was a little taken aback with this settlement agreement. It seemed like it, and some of the language in the letters and the things accompanying it, I keep seeing in its entirety, and that I think one paragraph, I've got it here in front of me, is that our approval should be limited as to a finding that it's a reasonable step. I feel like a little bit like the commission's being pushed away as far as the statutory obligation that we have. And I know our ORS put some good language in there about reviewing at the proper time as far as the numbers, but it's kind of strange to me to be sitting here approving something that really doesn't do anything other than just say it's reasonable. Why we would just not approve just the framework, but anything beyond that at this point. I know we've had some very involved cases with other companies like this, and I'm just trying to understand it. And that's not a question.
No, well, I mean, if I may respond, it wasn't a question, but if I may respond.
Help me any way you can.
So certainly the settlement agreement, I don't believe it by any party, but certainly not by the company, was intended to bind the commission in a way that made any commissioner feel like they weren't getting to exercise the authority that the General Assembly gave them. I think we were trying to resolve issues in dispute. Every utility in South Carolina has solar in their IRP, and we're not any different. And the question for us is, how do we go about procuring it? And so that's what we put forth before the commission. I think it can, the North Carolina topics can get confusing, but when you get down to the get down, we have an amount of solar in our RFP. We got to go get it, and we want to make sure that we're getting it the right way, and we want to make sure that South Carolina wants it for all the reasons that we described in this proceeding. And so that's why we're supportive of the settlement agreement, because understanding that if the commission approves it, that we're on the right track, and that our procurement program and that the RFP is a reasonable step for 2022. That's the other thing. We're just talking about 2022. But at this time, this is the right direction to go into. That's important for us to know. It's probably a little bit more important for us to know than maybe other utilities, because they may not have these dynamics that we're talking about. But if we look at North Carolina law and work backwards, it gets very confusing. If we look at South Carolina IRP volumes, getting it, are you getting it in a reasonable way, and are you getting it for the right reasons? That's how I got to a place where I could be a witness in this case and file the testimony that I did.
Okay, and I think maybe what I was trying to say was, where do we go from here? And that's a pretty good answer of that. We will, of course, be able to review the prudency of what you're doing and safety and that sort of thing in the future. Okay, thank you very much. Thank you, Madam Chair.
Thank you, Vice Chair. Good morning. How are y'all this morning?
Good morning.
Ms. Farber, I want to start with you if I may.
Sure.
In response, I'm not sure if it was Commissioner Caston or, well, it might have been Commissioner Thomas with regard to the affiliate being sold. And I think you made a statement that affiliates were not allowed to participate in the 2022 CPRE.
That is correct.
Explain that statement to me.
So at the time that the RFP launched, that portion of the business had not yet been sold. And so because it was still part of the holding company, it was an affiliate. And there's sometimes a perception that they might be treated
So
differently.
none of the affiliates no Duke affiliate or Duke entity participated in the 2022, submitted bids in the 2022 RFP?
Yes, but I will clarify, affiliate is different than Duke Energy Carolinas
Okay.
and Duke Energy Progress.
Well, and that's why,
Okay.
and I'm looking at your public version of your supplemental exhibit 1, because if you want to turn with me to it's page 17 of the Charles River Associates report, and I'm looking at the public version. I also have the confidential version, which we need to talk about how that was filed after the hearing.
You said page 14?
Page 17. I'm looking at the page number of the report, not, I don't know if you have the watermark that goes down the side that after it's filed
Okay.
here. I'm looking at page 17 of the report. It's table 5, utility ownership track selected proposals.
Is this the post-solicitation report or the
I
pre-solicitation
think this is
report?
the
I want to make sure I'm
post.
looking at the right thing.
It's the post. It's your supplemental exhibit 1.
I have it now.
Okay. Page 17.
Yes.
And I'm not going to ask you any of and I don't know if you've got what's confidential and what's not. And that's what was throwing me, is because Duke Energy Carolinas can submit a bid. I want to talk about the proposal. Duke Energy Carolinas can submit a bid in a CPRE solicitation.
That's correct.
Okay. Or Duke Energy Progress if it's in their territory.
That's correct.
I just want to understand.
Sure.
Understand that. So, this is not confidential that I can see because it's not redacted.
Mm-hmm.
Who is Bird's Eye Renewable Energy?
That is a third-party company. It is not affiliated with Duke Energy.
But that's
Carolinas.
under utility ownership track.
I can explain.
Okay.
So they developed the asset in the early stages, and so they are transferring the ownership of that asset to
I understand.
Duke Energy Carolinas or Duke Energy Progress. And so the bidders in that utility ownership track could be what we call a self-developed project, meaning DEC or DEP is involved from the very start and owns it from the very start. It could be an asset transfer only, which is pretty early stage development of the project, but they're involved in some siting work, some permitting work, site control. There was another flavor of this. It's asset transfer plus EPC, which is when they're doing the engineering and procurement and construction work as well. And then finally, the fourth flavor of utility ownership track is build, own, transfer. And that's when the developer builds the entire project, and upon mechanical completion, really when the project is done, that's when ownership actually transfers to DEC or DEP.
Okay. Thank you for that
Sure.
clarification. I'm also seeking clarification, it can be from any of you, on back to that 55-45 utility ownership versus third-party ownership split. In a procurement, if the commission approves the program, let's use a hypothetical. If the commission approves the settlement agreement, approves the program, and a RFP is put out, is that 55-45 split, does that have the potential to put a utility project ahead of a non-utility project if the non-utility project were to score higher? Does that make sense? Does that 55-45 split pertain to each procurement segment, or is it an overall amount? Because in a procurement, I'm just wanting clarification. Would that give the utility bid preference over a lower non-utility bid if you've reached that threshold?
So in the procurement, they're evaluated separately. There's no scenario where a utility ownership track project competes against a PPA project.
I don't think I picked up on that.
Okay.
I think that clarifies my question. Thank you. Is there, if the commission were to approve the program and the settlement agreement in the program, and as things move along, is there the possibility of Duke coming back in and asking for amendments to the CPRE guidelines, the program parameters?
The exact rules of the RFP will probably change a little bit over time as we try to refine our procurement process and learn from the last round as we develop the next.
And that's what I was getting at. I mean, if you see, well, this worked really well, this might not have worked as well, let's try this. Is that something that is out there?
So yes, and as part of the stakeholder process leading up to the launch of each RFP, we are trying to take those lessons learned forward, share that with the stakeholders, with the independent evaluator. By and large, I think the bulk of the RFP rules will stay the same year over year, but there's always room for improvement and learning, and so we want to be able to incorporate those lessons learned as we go.
And if there are changes, those would have to be brought back to the commission, would they not?
If the commission wants to review them, absolutely.
Okay.
If I could add on to that,
Yes, ma'am.
I think this is another place we'd really like to understand some direction from the commission to make sure that we're in step with what the commission would like for us to do. For example, in that 2024 RFP, if the commission would like to, for us to come back and report on how it's going, where are we, what is different about the RFP, if the commission wishes to be us to come early in that process, that is something we can do. Or do you prefer, to see it on the tail end or throughout? So I think we're sort of midstream on the 2023, but I think that's why perhaps that, generic docket to maybe talk about some rules of the road about when we come back before the commission, just to address those kinds of things, might be really helpful to the process to make sure we're moving along the lines of what the commission wants us to do.
Okay, thank you. Ms. Smith, I think you stated in your pre-filed testimony that this proposed procurement model, and it may have been in your your settlement testimony too, is the most cost-effective way to procure additional solar. Did I say that correctly, you think? Can you expand on that for me a little bit?
Yes, for the solar that we're procuring and for the attributes of that solar, having this competitive process with the two components, the reasonable balance that we've put forward, is the best way, we believe, to bring volumes of solar online to our system and in the interest of customers, because it makes sure that we're getting the best sites, the best places to interconnect to our system, that we are getting projects that we believe will materialize, although I think some may drop out here and there if it no longer meets their business case. But having this disciplined process versus relying on solar that may or may not come through traditional PURPA avenues is important for us as we look at our all of the above energy strategy. So we think this is the best way to go about it in terms of bringing solar online to our system.
Thank you, ma'am. I know in your pre-fall testimony, Ms. Smith, you had some discussions on cost recovery, and I know that the deferral issue has been removed from where we are now. Under the settlement agreement, I was pleasantly surprised to see 3 subparagraphs addressing that. But my understanding of the settlement agreement is that any cost would be recovered in the normal regulatory proceeding, a rate case, a prudency review, just the normal principles that are applied in a rate case. Is that correct?
That is correct, and I think I would add to that a little bit. You know, this is since Act 62 gives us an opportunity to come in and bring these matters before the commission. Getting that nod that we're on the right track is very important to us. It is a little bit of a red herring in terms of the other processes that we do. For example, if we were building you know, a central station generation unit in South Carolina over 75 megawatts, we would, you know, have an additional process in between the IRP and a rate case that would involve that CECPCN. This is a little bit like that step in between an IRP and a rate case for us. And so the normal looking at you know, what the costs and the projects are, and what's in service, and you know, what's serving South Carolina, all of that is normal within the base rate case process in our view, as well as the fuel case process for third-party contracts. Now, we did take the deferral request out of this case. We may or may not bring that back depending upon the financial circumstances of when those assets hit. So that's, I can't say that we're not.
No, I'm not saying that issue's gone away. It's just been taken out of this case.
Yes, Commissioner.
Certainly understand that. It would be like any other deferral that the company may seek.
Exactly.
So, okay. Thank you very much. Panelists, thank you very much for your testimony. Ms. Snyder, I'm sorry I don't have anything for you.
Next time, Commissioner.
Okay. I would say count on it, but we never know. So. Commissioners, anything further? Commissioner Carolee Williams.
Let Judge Urban go.
Oh, I didn't hear him. Judge Urban? Okay.
Yes.
I'm sorry, I didn't hear you. Excuse me.
All right. Ms. Smith, just to kind of put it in some perspective, what we're talking about here, can't 2 things be true at the same time? And what I mean by that, your plan for competitive procurement process for both North Carolina and South Carolina can at the same time comply with North Carolina law, but it also at the same time can comply with least cost for South Carolina ratepayers. Isn't that true?
I absolutely agree, Commissioner, that 2 things can be true. I would also say that that we have greater responsibilities and accountability to this commission in addition to least cost, meaning reliability and making sure the kilowatts are there when we need them. So that would be the only thing I would add to that, but I absolutely agree with your statement that 2 things can be true.
And I was going to get to reliability, but I'm trying to look back on lessons learned, and particularly lessons recently learned. If we go back to this time last year, December of 2022, I'm not sure anyone would have anticipated that our fossil fuel assets like the gas plants and the coal plants failed to perform during Winter Storm Elliott. And it was the solar assets that the company had that continued to provide safe, reliable, affordable energy. Isn't that a lesson learned that we need all of the above?
I think the lesson learned, sir, that we need all of the above is actually underscored. I agree with you that it was unanticipated. I don't think we could have anticipated that, about 1,000 megawatts of firm purchase power wouldn't show up. That kind of weather, as I'm sure you remember, sir, coming right on the heels of that terrible windstorm was something we hadn't seen before. And, the fact that we did have some challenges at our plants, which also hadn't experienced those kinds of conditions, especially that early in the winter season. All of those were very important lesson learned. While solar was not operational at our winter peak in that time frame, it did add tremendous value in helping us be able to access our storage at Bad Creek. So while solar operated as intended during that time frame, as intended means we were able to access storage from prior days. That was a big benefit to us from the contribution of solar. And then, of course, it was there when the sun came up.
Thanks. And another lesson recently learned, about a year and a half ago, was when natural gas prices peaked to the point that we saw double-digit increases in South Carolina electricity rates because of the fact that natural gas prices more than double in less than a calendar year. So can't we learn a lesson from that experience, having recently gone through rate cases for fuel that could have been avoided had we had a more diverse generation base?
Yes, sir. I don't know that the increases could have been completely avoided, because we do need assets for reliability that have costs associated with them. But if we had more solar, the mathematical presumption that more solar would have put an additional downward pressure on those fuel rates is correct.
And had we had storage, battery storage coupled with the solar, it would have been dispatchable and have been even more of a valuable resource during that time. Would you agree?
Yes, I absolutely would, and that's one of the reasons we're aggressively pursuing storage.
Great. And finally, it's hard to argue with facts. So I went back, and just thought about the cost of solar and how it's dropped dramatically over the last 10 to 12 years. And just to put it in some perspective, if you look at the levelized cost of solar, would you agree that it's now the cheapest available resource compared to natural gas, oil, coal, and nuclear?
Yeah, I'm going to turn over part of my answer to Mr. Snyder. I would say absolutely that solar would dispatch first in the stack when we're serving the system, because there's no fuel cost associated with it, and subject to reliability. So I don't know if it's the cheapest resource overall, or how that plays in. I just know it's an incredibly important, cost-efficient resource for us, in addition to the resources we need for dispatchability and load following characteristics. Now, can you clean me up, please, Mr. Snyder, on if I said anything wrong?
No, that was absolutely correct. And I think it's again, the all of the above strategy recognizes resources have both costs and benefits, and that's why you need an array of resources. So, it can be a really economic choice when the sun is shining, but then you also have a need for resources when the sun isn't shining. And so then you have to incur either storage or rely on other resource types. And so I always find it challenging to say any one resource is the cheapest resource. They all have different benefits to them, and they all have different costs to them. But But we see that solar certainly is an important part of a diverse resource mix, as now 3 consecutive IRPs have pointed out. I don't know that I would characterize it as a blanket statement that it's the cheapest thing out there, because, you know, they all have different benefits. You know, so I just sort of leave it at that.
But certainly, sir, it's become a lot more attractive in the time frame that you've referenced.
Absolutely.
Right. And so lease cost is certainly going to continue to be a consideration, not only for Duke Energy, but for all the investor-owned utilities as they try to fashion energy mix going forward. Would you agree?
Yes, sir.
And for that reason, do you think that the compromise settlement agreement that you and the parties have reached is in the best interest of South Carolina ratepayers?
Yes, sir.
Do you also think it provides all of the above diverse portfolio of generation resources that best suits and fits the needs of Duke Energy going forward in the Carolinas?
Yes, sir. We believe that it's a important part of that diverse mix, as you referenced.
And the added benefit of a competitive procurement process is that you, again, have another shot at getting not only the least cost resource, which is solar, but a competitive least cost bid, which means it is an extra benefit when you have people bidding to be the low bid, right?
Yes, sir.
Thank you. No further questions.
Commissioner Carolee Williams?
Thank you, Chair Belser. I've got one quick follow-up question. And now I've forgotten who talked about if one of the PPAs were to not be able to continue forward, if they dropped out. What happens at that point? Is that just rolled into the next process, or are you able to look to the next one in line that responds to the CPRE in that year?
It depends on the timing of when that project drops out. So if we are still in a part of the interconnection process that they can keep moving forward, then we could potentially seek sort of the next project in line. If we've moved on in the interconnection process, then we would have to seek that makeup quantity in a future RFP. Our RFP timeline is very closely aligned with the interconnection timeline process, and there are some very prescriptive dates and requirements for interconnection in order to keep moving forward in that process.
Thank you very much. That's it.
Mr. Welborn or Mr. Brightsworth, any redirect?
Thank you, Madam Chair. Just really limited one issue, if that's all right.
Mm-hmm.
Thank you for your indulgence. Ms. Smith, do you recall a commissioner asking about a 20-year useful life for solar resources?
I do.
Do you recall that the commission's orders on this issue, in particular, order number 2021-569, subject to check, address net energy metering, in other words, rooftop solar for customers?
I do.
And didn't the customers procure utility scale solar resources through the 22 RFP rather than rooftop net metering resources?
Correct.
Thank you. No further questions, Chair. Thank you.
Thank you. Anything? Okay. Do you have something? You. Thank you, panelists. Appreciate your appearance this morning and your testimony, and you may stand down.
Thank you.
We've been going a couple hours, almost a couple hours, so let's take a 15-minute break. We'll return at 11:40. And Mr. Witt, I think your witness is up next.
That's correct.
Thank you. Good morning and welcome back to the Public Service Commission as we continue in the hearing in docket numbers 2022-239-E and 2022-240-E. Let's take a roll call of commissioners. With us virtually, we have Commissioner Urban. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. We are now on interveners and recognize Carolina's Clean Energy Business Association. Mr. Witt.
Chair Belser, I apologize for the interruption. I'm sorry. I'm so
Mr.
sorry.
Wilburn?
And apologies to you,
Oh.
Mr. Witt, for the interruption. Our witnesses have presented their testimony, are not expected to be recalled, and I did not have an opportunity previously. To make this request. I would ask that they be excused from the stand so that we can have lunch and do that whole thing, if that pleases the chair.
That's at your peril.
Understood, Chair.
Y'all always know what my answer is going to be, and yet y'all continue to ask. So. Anyway, thank you, Mr. Wilburn.
Thank you, Chair. Pardon me again. Thanks.
Okay. Mr. Witt.
Thank you, Chair Belser, members of the commission. Sasiba's witness is Hamilton Davis. Has he been sworn? Mr. Davis, state your name and business address.
Hamilton Davis, 1519 King Street Extension, Charleston, South Carolina, 29405.
Who are you employed by? You gave us the address.
Southern Current.
Okay. On whose behalf are you testifying today?
CCBA, the Carolinas Clean Energy Business Association.
Did you prepare, cause to be prepared for free-file testimony consisting of 14 pages?
I did.
If I ask you those questions today, would your answers be the same?
They would be.
You have no changes or corrections to your testimony?
I do not.
Chair Belser, we'd like to move Witness Davis's pre-filed testimony into the record as if given orally from the stand.
Mr. Davis's pre-filed direct testimony will be entered into the record as if given from the stand.
Mr. Davis, do you have a summary of your testimony?
I do.
Can you present that at this time?
Yes, I will. Good morning, Commissioners. Chair Belser, it's good to be in front of you all again today. I've got two summaries, actually. I'm going to start with mine before I adopt my testimony of Steve Levitas. My name is Hamilton Davis. I currently serve as the Vice President of Regulatory Affairs for Southern Current. I have a Bachelor of Science degree from Clemson University, a Juris Doctor degree from the University of South Carolina School of Law. In my employment, I manage the company's regulatory engagements before the Federal Energy Regulatory Commission and multiple state utility commissions, including the South Carolina Public Service Commission and the North Carolina Public Utilities Commission. My work also supports the company's policy initiatives before various state legislatures, as well as the company's commercial interest in wholesale and vertically integrated markets across the country, including contributions in the creation of and participation in renewable resource procurements. I'm testifying on behalf of CCBA and have previously testified and provided allowable ex parte briefings before this commission. My most recent appearance was as a witness on behalf of CCBA in the 2023 Dominion Energy South Carolina competitive procurement of renewable energy proceeding. My revised direct testimony discusses how Duke's 2022 solar procurement is consistent with the company's approved integrated resource plan. I also set out the expected timeline for procuring and constructing renewable resources to achieve the goals of Duke's most recently approved IRP and how that timing should affect CPRE program design. My supplemental direct testimony addresses a number of matters discussed in the supplemental direct testimony of Duke witness Heather Shirley Smith, filed in these dockets on August 18th, 2023. My direct testimony includes an overview of the recently approved 2022 Duke IRP and details the additions of solar and storage resources that have been identified in that plan. For the 2022 IRP update, this commission found that the company's IRP was in the public interest, and the update included an addition of 750 megawatts of solar to be added to its system in late 27, with an additional 441 megawatts of solar being procured pursuant to North Carolina House Bill 589 and 300 megawatts of solar in the North Carolina Green Source Advantage Program. This additional 741 megawatts of assumed solar has not yet been procured or contracted as expected in the 2022 IRP. thus combining the uncontracted solar megawatts with the additional solar selected by the model in 2027 results in an expected 1,491 megawatts of additional solar. This volume is consistent with Duke's 2022 competitive procurement, which targeted a maximum of 1,440 megawatts of additional solar to be placed in service by 2028. Therefore, I conclude that the 2022 Duke solar procurement is consistent with Duke's IRP and should be approved by this commission. I further review additional support for the cost effectiveness of the 2022 solar procurement as seen in the 25-year avoided cost rates filed on December 15th, 2022, with the North Carolina Utilities Commission showing that Duke's 25-year avoided cost rates are significantly higher than the cost at which solar can be competitively procured, inclusive of any network upgrades, further supporting the conclusion that the 22 solar procurement will result in substantial ratepayer savings for Duke's customers. CCBA supports the use of an approved IRP as a proper foundation for informing the need and timing of renewable energy and storage procurement. It's also reasonable to rely on other commission-approved planning processes to further inform this analysis. My revised direct testimony also discusses the lengthy lead time required for the development, approval, and utilization of a CPRE program. I note that from the design and implementation of Duke's RFP to the in-service date for selected facilities, that timeline represents between 4 and 6 years. Given that Duke has identified significant additions of solar resources during this time horizon, CCBA recommends that this commission approve the Duke 22 procurement in this proceeding and establish commission expectations for future procurements. I'll review the materials that were created through the stakeholder process in Duke's 22 solar procurement, and I'll also discuss the expected timelines associated with interconnection studies, which take between 630 and 780 days from the close of the project enrollment window to interconnection agreement finalization and payment, with the longer timeline assuming a Phase 3 study is necessary. To the extent that any network upgrades are required to interconnect new resources, that could add another 2 years from the end of the interconnection study. And in addition, while construction times can vary for specific projects, it's typical for a facility construction to take 12 to 24 months. However, this can be done in conjunction and sequentially or concurrently with interconnection upgrades. Based on the timelines described above, the 22 solar procurement would allow for selected facilities to be placed in service between late 2026 and 2028, which is consistent with Duke's 2022 IRP. Additional solar and storage procurements will also be required in the future to meet the resource additions included in Duke's 22 IRP. And this concludes the summary of my direct testimony. In my supplemental direct testimony, I comment on Duke witness Heather Shirley Smith's supplemental direct testimony filed on August 18th, 2023. CCB agrees with witness Smith that Duke's procurement of the solar resources selected in the 22 procurement is in the public interest. While it is true that Duke's 22 solar procurement was expressly authorized by the North Carolina General Assembly and approved by the NCUC, it is nonetheless also in the best interest of South Carolina ratepayers. For the reasons previously discussed, there can be no question that the near-term procurement of far more solar than is included in the 22 procurement is needed to ensure the least cost, reliable operation of Duke's system. And solar is demonstrably one of the least cost energy resources available in the Carolinas today and has performed reliably as compared to other resources in both winter and summer extreme weather events of late. Continued reliance on coal-fired generation presents substantial risk for South Carolina ratepayers due to fuel price volatility, more stringent federal regulations, and operation and maintenance costs and challenges resulting from facility age. Though the exact amount of solar needed to be added to Duke's system over the next decade is still to be determined, it is no doubt significantly larger than the volume covered by the 22 procurement. Moreover, it will not be possible to interconnect the needed volume of solar and solar plus storage over the next decade without steady progress through annual procurements and additions. I agree with witness Smith that the Commission should generally approve procurement of the 22 selected resources in this proceeding. It is extremely important that this commission or any other state regulatory commission provide approval of utility procurements in advance of project development and construction processes. However, the prudency of actual expenditures as opposed to project selection will always be subject to review in the cost recovery process. Commission review and approval of resource programs and procurements is particularly important as utilities move toward greater competitive procurement of generation resources as envisioned by Act 62, as competitive procurement is widely recognized to be beneficial to ratepayers and was recognized recently in the Brattle Group's report to the South Carolina General Assembly as providing those benefits. It would be inefficient and impractical to defer consideration of the 22 procurement to a later time in a separate proceeding. And this concludes the summary of my my supplemental testimony. Thank you.
Thank you. Chair Belser, if I may, I'd like to ask this witness a couple questions to lay a foundation for him to adopt witness Levitus's testimony.
Please proceed.
Thank you. Mr. Davis, are you aware that Sasiba witness Levitus previously filed testimony for this commission consisting of 20 pages?
Yes, I am.
Have you reviewed and are you familiar with the revised testimony that was filed by Sasiba witness Levitus?
Yes, I am.
Accordingly, are you able to adopt the testimony of Sasiba witness Levitus, and are you prepared to summarize and answer questions concerning his testimony?
I am.
Chair Belser, we would like for to be allowed to have witness Davis adopt that testimony.
Mr. Davis will be allowed to adopt the pre-file testimony submitted by Mr. Levitus.
Thank you, Chair Belser. Mr. Davis, do you have any changes or corrections that need to be made to witness Levitus's pre-file testimony?
I do not.
If I ask you the questions in witness Levitus's pre-file testimony, would your answers be the same?
They would be.
Based on that, Chair Belser, we'd like to move witness Levitus's testimony into the record as if given orally from the stand.
Mr. Levitus's pre-file testimony will be entered into the record as adopted by Mr. Davis.
Thank you. Do you have a summary of witness Levitus's testimony, Mr. Davis?
Yes, I do.
Can you please give that?
My revised direct testimony begins by discussing the benefits of a well-designed CPRE program. The first and biggest benefit is what we see from competition across our economy. Competition drives down prices and improves the quality of services for consumers, as multiple sellers must strive to innovate and achieve efficiencies or accept lower returns in order to acquire and maintain market share. Additionally, competitive procurement by definition involves opening the market to independent suppliers rather than allowing investor-owned utilities to self-develop all generation assets. This diversity of suppliers results in access to broader and more diverse development expertise, many additional sources of capital, and a larger workforce for the development and construction of generation facilities. And to the extent that competitive procurement involves execution by the utility of power purchase agreements with third-party suppliers rather than utility ownership and rate basing of generation assets, those third parties bear the risk of cost overruns as well as any performance shortfall following commercial operation. In response to the specific questions that the Commission asked parties to address in this proceeding, I offered the following responses and opinions on behalf of CCEBA. First, CCEBA strongly believes that utility competitive procurement should be driven by an IRP or similar resource planning processes. The most important threshold question in the procurement of generation resources by regulated utilities such as Duke are the volume of generation capacity needed and the specific type of resources needed, including required performance characteristics of those resources. These questions are best answered through a comprehensive, transparent, and inclusive planning process. Second, CCEBA recognizes that there are benefits to so-called all-source procurement in that they provide an opportunity for the utility, with the approval of the Commission, to develop an optimal resource portfolio after determining the actual capital cost of various generating resources, rather than having to rely on estimates or projections of those costs. However, CCEBA understands that the focus of this proceeding to be on the procurement of renewable energy as provided by the South Carolina General Assembly through Act 62 of 2019, which authorized this commission to develop a competitive procurement program specifically for renewable energy resources. Third, CCEBA believes that a least cost and least risk energy supply that best serves ratepayers and the public should include independent market participants in competitive solicitations, Not only have independent power producers such as our companies and other CCBA members consistently been able to deliver renewable energy at lower cost for customers, but independent power producers rather than the ratepayers also bear the risk of delay, cost overruns, and underperformance in a way that rate-based assets do not. Fourth, we agree that there should be reasonable and transparent eligibility standards that are developed through a stakeholder process and approved by this commission. Fifth, assuming that utilities are allowed to participate as market participants in a CPRE process to ensure a level playing field and avoid any appearance of impropriety, the utility should be required to maintain a strict firewall between its bid teams and its evaluation team. Six, our understanding is that most competitive solicitations for electric generation resources by investor-owned utilities in recent years have involved some form of independent oversight. The key question is whether the solicitation is fully administered by an independent third party, which we refer to as an independent administrator or an IA, or whether the utility should be allowed to administer the program under the oversight of an independent party, typically referred to as an independent evaluator or IE. In our opinion, the answer to that question turns on how the program is designed and specifically on whether and how the utility and/or its affiliates are allowed to participate in the procurement. To the extent that the utility or its affiliates are allowed to compete directly with independent suppliers, the need for an IA is much greater. Regardless of the choice between an IA and IE, the utility and that party should work together with stakeholders on the design of the program, including scoring criteria, weighting of those criteria, and the evaluation selection process. While we would recommend that certain elements of program design be subject to commission approval, it may not be necessary for all RFP documents to be approved by the commission. Seventh, we believe that it's in the public interest for bidders to have as much information as possible about the transmission and distribution systems and where new generation can most cost effectively be sited. If utilities and their affiliates are allowed to participate in the competitive process, it's essential that all market participants have access to the same information about the transmission and distribution systems as the utility does. Eighth, we acknowledge that states, including North Carolina, Virginia, Colorado, and Michigan, have provided for a specific mix of third-party owned and utility-owned generation. Where that occurs, the two types of resources are typically procured through separate requirements within the procurement process, not in competition with each other. Regardless, we believe that generation that will be utility-owned should itself be competitively procured, and third parties should have the ability to compete with the utility and its affiliates to supply these resources. And to be clear, we do not think it is appropriate for utility affiliates to compete in third-party procurements. I also testify that I believe the creation and authorization of a CPRE program, generally speaking, is certainly in the public interest for the utilities balancing area. In my direct testimony, I also identify competitive procurement programs that have been implemented by utilities in other southeastern states. In addition to North Carolina, those include Dominion Energy Virginia, Georgia Power, Alabama Power, Santee Cooper, and the Tennessee Valley Authority. Our direct testimony provides links to detailed information about these programs. In my supplemental direct testimony, I respond to the supplemental direct testimony of Duke witness Heather Shirley Smith, filed on August 18th, 2023. In particular, I state that a reasonable split between third-party and utility ownership of generation assets is needed. From experience, I can say that attempts to establish a precise allocation on empirical analysis of benefits and costs are extremely complicated and have not been successful. Duke's 2022 split of 1/3 utility ownership and 2/3 third-party ownership is certainly within the range of reasonable outcomes. Finally, I conclude by stating that Duke has significant near-term solar additions identified in its approved IRPs, and competitively procuring those resources in a timely manner will result in a cost-effective and predictable mechanism for meeting those needs consistent with the public interest. Due to long lead times required for the creation and approval of a CPRE program, combined with lengthy interconnection study and construction phases of CPRE, it is appropriate that this commission approve Duke's 2022 solar procurement as being in the best interest of South Carolina ratepayers. I propose that this commission should set a deadline for Duke and other interested parties to propose a process by which future competitive procurements for solar and storage resources can be evaluated and reviewed by this commission so as to align with any necessary approvals from this commission and the North Carolina Utilities Commission in a timely manner. And this completes the summary of my testimony.
All right, thank you. Chair Belser, witness Davis is available for questions.
Thank you, Mr. Witt. Commissioners, questions for the witness? Commissioner Caston?
Thank you, Madam Chair. And one question. Good-
Commissioner, how are you doing?
I think it's good afternoon now. I'm not really sure.
That felt like it took half the day to read through those summaries, so it certainly feels like the afternoon.
I understand. And you mentioned in the closing part of that, Mr. Levitis's comments, I think on page 18, his supplemental direct, where basically talks about, there's no, I guess precise allocation method, no one way to do that. And relative to that 55% utility owned, 45% third party weighted average, are you, SECIBA, satisfied with that?
I think on, I think the 22 procurement, didn't actually strike that balance. So it's the largest, 2/3 IPP, 1/3 utility. And that 45-55 split is really over the course of the entire kind of, portfolio of solar at some point in the future. And so every procurement may have a slightly different allocation. I think that's that decision hasn't been made for other utilities in South Carolina. That exact split is a consequence of North Carolina law, and I think we've certainly been comfortable with it for purposes of the previous procurements and near-term procurements. But I view it as an open question as we move forward in South Carolina as to exactly how the commission or the legislature ends up handling that.
Okay.
But I think our testimony is that it's reasonable, absolutely.
All righty. Mr. Hamilton, that's all I got.
That's it.
Thank you, sir.
All right, thank you.
Commissioner Carol Lee Williams?
Thank you, Chair Belser. Good to see you again.
Good to see you.
Just a few follow-up questions. We talked earlier this morning about the 25-year time of reference for PPAs versus 30-year for the utility. I'll just give you an open-ended. What do you want to add to that in terms of the rationale for that, how SECIBA looks at that, and also kind of the evolution? Because even in our 3 years of serving on the commission, there was a lot of conversation about the life of solar 3 years ago, that this is very different than what we heard testimony-wise. So,
I mean, I'll just say I think there are certainly different perspectives in the IPP community and in the finance community around what they would prefer the tenor to be, and a lot of that has to do with assumptions on the tail end of the facility. So you assume it's going to be operating for 35 years. Would you rather have a locked-in contract for that entire term, or would you rather anticipate that there will be more value if you recontract at year 25? And so it's really more about finding that sweet spot, I think. Duke, prior to the 22 procurement, was using 20-year PPAs and have now moved to 25. I think we're, as an industry, generally, we've been comfortable with either of those. Again, like, you can comment on why one's better than the other, but I don't think there's a right answer. I think it's more of where the market is at any given cycle. And as far as the stakeholder process, and I think the feedback that we've provided Duke and others, 25 years has been kind of reasonable and preferable for these last couple of years.
So is that also saying that there's no concern about not having 30-year for PPAs?
No, I think what you want to make sure of in the evaluation process is, to the extent that they're like how much IPP solar is being procured in 1 year versus utility owned solar. So like that split's not always going to be 45, 55, and sometimes you're going to get more cost effective, like a larger bucket of cost effective IPP solar that you may want to take more from and skew in that direction. And so, under those circumstances, you want to make sure you're able to evaluate the 30-year versus the 25-year, or if you're modeling it in IRP, you want to make sure that there's an apples to apples kind of consideration in terms of how the resources are being represented in a IRP portfolio. But I wouldn't say there's any. I don't see any heartburn around the 30 versus 25 as it currently exists.
Okay. And I think you covered this, but I'd like you to elaborate a little bit more on the idea that witness Smith offered about opening a docket to look at future RFPs and how we process those.
Yeah, and I think witness Farver spoke to this as well. That a lot of this is live and learn, and so as the technologies change, as as hybrid resources become, solar plus storage become more common, and just the markets change, like you want to be able to iterate on what has worked and fix any problems that have arisen. So having some process for doing that, certainly we encourage the stakeholder process to continue and make sure there's that dialogue between the industry and the utility and others that have an interest in how these programs are designed and run, but also having an opportunity for issues to be resolved in front of the commission to the extent that's needed, and for you all to understand what is being done, what changes are being made. And so I think there's general agreement that these procurements, you all should have visibility into them and how they evolve over time.
Do you have a suggested time frame by which we need to?
I think what we recommended in our in my test, I can't remember if it was my testimony or Steve Levitis's, but that you all charged the participants in the proceeding with proposing kind of a structure for how we make this a regular feature of your considerations.
Thank you very much. No
Yes, ma'am.
further questions.
Commissioners, further questions for this witness? Commissioner Thomas?
Thank you. Good afternoon.
Good afternoon.
So I assume you heard the question and answer with the prior panel about Duke and their sale of the renewable business, which was non-utility, and my question about potentially purchasing power from those facilities that they sold. And so I just wanted to ask, from your perspective, do you see any problems with that? Do you think that you or your business or relationships would be on fair footing in that regard?
Yeah, I think that the optics there are tricky, but my understanding is similar to Witness Smith's, that the Duke Renewables was their commercial development side, and they didn't own any assets in Duke service territory, their regulated service territory. So I just don't think there are projects that that would even be available for them to purchase power from. I think most of they were developing assets in Kansas and Texas and, other states outside of their direct served territory.
All right. Thank you. I appreciate it.
Commissioners, anything further? Mr. Witt, any redirect?
No redirect.
Thank you. Mr. Davis, thank you for your appearance and your testimony today. We appreciate your
Yeah,
insights and
absolutely.
your
I appreciate
testimony.
the commission's time and look forward to seeing you all again soon. Thank you.
You may stand down. Mr. Witt, anything further?
Nothing further.
Thank you. Office of Regulatory Staff?
Thank you, Madam Chair. We would call Ms. Dawn Hill.
Thank you.
Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Hipp, once you get situated, could you please state your name for the record?
Good afternoon. My name is Dawn Hipp, and I'm with the Office of Regulatory Staff, and I serve as the Chief Operating Officer.
And by whom are you employed and in what capacity?
I'm employed by the ORS as a Chief Operating Officer. Sorry, I got ahead of you there.
Sorry. All right, well, Ms. Hipp, if that's the only hiccup that we have, then I think we're doing well. Like Mr. Welborn, and we're going to try to get through this as quickly as we can, so everybody just bear with us while we try to adopt this testimony. Ms. Hipp, are you aware that Anthony Sandonato pre-filed direct and sir rebuttal testimony in connection with this proceeding?
Yes, I am.
And subsequent to filing his testimony, Mr. Sandonato accepted employment elsewhere and is no longer an employee of ORS. Is that correct?
That's correct.
Okay. And is it your intention to adopt the pre-filed testimony of Mr. Sandonato?
Yes, it is.
Okay. And on December 8th, 2023, did ORS file amended versions of both your and Mr. Sandonato's testimonies?
Yes, we did.
Okay. And was the purpose of those amendments to delete those portions of the testimony related to the company's deferral request, which they have since withdrawn?
Yes, it is.
Okay. Ms. Hipp, have you reviewed Mr. Sandonato's amended and direct sir rebuttal testimonies?
I have.
Okay, and we'll get to some of the specifics, but as a general question, do you agree with the position set forth in Mr. Sandonato's direct and sir rebuttal testimonies?
Yes, I do.
Okay. All right, let's start with his amended direct testimony. Have you reviewed that testimony, which consists of 14 pages?
Yes, I have.
And do you have any corrections, additions, or deletions to Mr. Sandonato's amended direct testimony?
No, I do not.
If I were to ask you the same questions set forth in his amended direct testimony, would your answers be the same?
Yes, they would.
Okay, therefore, are you adopting Mr. Sandonato's amended direct testimony as your own?
Yes, I am.
Okay. Madam Chair, I would ask that Mr. Sandonato's amended direct testimony as adopted by Ms. Hipp be entered into the record of this proceeding as if given orally from the stand.
And that's the testimony that was filed December 8th, is that correct?
Yes, ma'am.
Okay, yes. Mr. Sandonato's amended direct testimony will be adopted by Ms. Hipp and entered into the record of this proceeding as if given from the stand.
Okay. And Ms. Hipp, Mr. Sandonato's amended direct testimony contained one exhibit, AMS1, is that correct?
Yes,
Okay, and the original version of that exhibit contained 13 pages, is that correct?
that's correct.
And the amended version that was filed on December 8th contained only 8 pages. Was that to delete portions of the exhibit that related to the deferral request?
That is correct.
Okay. Other than that change, do you have any additional corrections, additions, or deletions to exhibit AMS1?
No, I do not.
Okay. Madam Chair, I would ask that Mr. Sandonato's amended exhibit AMS1 as adopted by Ms. Hipp be entered into the record as the next hearing exhibit.
The amended direct exhibit that was labeled AMS1 and attached to the amended direct testimony now adopted by Ms. Hipp will be marked for identification, a composite exhibit marked for, well, there's several parts, but it's just one, will be marked for identification as hearing exhibit number 5 and admitted into the evidence of this case.
Okay. All right, Ms. Hipp, let's turn to Mr. Sandonato's amended sir rebuttal testimony. Have you reviewed that testimony, which consists of 15 pages?
Yes, I have.
Okay, do you have any corrections, additions, or deletions to that testimony?
No, I do not.
And if I were to ask you the same questions set forth in his amended sir rebuttal testimony, would your answers be the same?
Yes, they would.
Okay, so therefore you are adopting Mr. Sandonato's amended sir rebuttal testimony as your own, is that correct?
That's correct.
All right, Madam Chair, I would ask that Mr. Sandonato's amended sir rebuttal testimony as adopted by Ms. Hipp be entered into the record of this proceeding as if given orally from the stand.
The amended sir rebuttal testimony of Mr. Sandonato as adopted by Ms. Hipp will be entered into the record as if given from the stand.
And Ms. Hipp, the amended sir rebuttal testimony contained one exhibit consisting of 11 pages. Do you have any corrections, additions, or deletions to that exhibit?
I do not.
Madam Chair, I would ask that Mr. Sandonato's amended sir rebuttal exhibit AMS-1 as adopted by Ms. Hipp be entered into the record as the next hearing exhibit.
The sir rebuttal exhibit attached to Mr. Sandonato's amended sir rebuttal testimony will be marked for identification as hearing exhibit 6 and received and admitted into the evidence of this case. Did I say that right?
I think so.
Okay.
All right.
Correct me if I'm, any of you, correct me if I misstated.
Okay. All right, we're halfway there. So, all right, let's go to your supplemental testimony, Ms. Hipp. In connection with this proceeding, did you prepare or cause to be prepared 14 pages of amended supplemental testimony?
Yes, I did.
Do you have any corrections, additions, or deletions to that testimony?
I do not.
If I were to ask you the same questions set forth in your amended supplemental testimony, would your answers be the same?
Yes, they would.
Madam Chair, I would ask that Ms. Hipp's amended supplemental testimony be entered into the record of this proceeding as if given orally from the stand.
Ms. Hipp's amended supplemental testimony will be entered into the record as if given from the stand.
Ms. Hipp, did you also file 4 exhibits with your supplemental testimony identified as exhibits DMH1 through DMH4?
Yes, I did.
Okay, do you have any corrections, additions, or deletions to those exhibits?
No, I do not.
All right, Madam Chair, I would ask that exhibits DMS1 through DMS4 be entered into the record as the next hearing exhibit.
Ms. Hipp's exhibits DMH1 through DMH4 attached to her amended supplemental testimony will be a composite exhibit marked for identification as hearing exhibit 7 and received into the evidence of this case.
Ms. Hipp, finally, did you prepare or cause to be prepared 13 pages of amended supplemental surrebuttal testimony with no exhibits?
Yes, I did.
Do you have any corrections, additions, or deletions to your amended supplemental surrebuttal testimony?
No, I do not.
And if I were to ask you those same questions, would your answers be the same?
They would.
Madam Chair, I would ask that Ms. Hipp's amended supplemental surrebuttal testimony be entered into the record of this proceeding as if given orally from the stand.
Ms. Hipp's amended supplemental surrebuttal testimony will be entered into the record as if given orally from the stand.
And I forgot one, so we've got one left. Ms. Hipp, did you prepare or cause to be prepared 3 pages of settlement testimony?
Yes, I did.
Do you have any corrections, additions, or deletions to your settlement testimony?
No, I do not.
If I were to ask you those same questions, would your answers be the same?
They would.
Madam Chair, I would ask that Ms. Hipp's settlement testimony be entered into the record as if given orally from the stand.
Ms. Hipp's settlement testimony will be entered into the record as if given from the stand.
All right, we did. Ms. Hipp, have you prepared a summary of your testimony?
I have.
All right, could you please provide that at this time?
Yes, I will. And maybe I'll just for fun go through all of the testimony that we put into the record. But no, we will make it brief for you. Good afternoon, Chair Belser and members of the Commission. My summary supports and explains the comprehensive settlement agreement reached between the companies and the other parties, including South Carolina Coastal Conservation League, the Southern Alliance for Clean Energy, Upstate Forever, and the Carolina Clean Energy's Business Association, and ORS. The comprehensive settlement agreement was the result of earnest, good faith, and complex negotiations. And in the spirit of collaboration, each settling party made compromises from their original positions to achieve a balanced resolution to all of the issues in this proceeding. ORS requests that the Commission approve the comprehensive settlement agreement as it was filed on December 8th. For context, there were several areas of disagreement between the companies and ORS, including whether the Commission should determine or affirm that the 2022 RFP is in the public interest for South Carolina, whether the Commission should provide clarification, guidance, or affirmation that the companies can and should allocate the South Carolina portion of the 2022 RFP selected projects to South Carolina customers in future cost of service studies and for consideration in future rate proceedings. And finally, whether or not the public interest requires or necessitates that this Commission predetermine and agree that the costs and benefits of the 2022 RFP should be shared between South Carolina and North Carolina before the companies have acquired, contracted for, or constructed the generation identified in the 2022 and 2023 Integrated Resource Plans. Through the settlement agreement, the companies and ORS agreed upon 2 major items. First, the RFP framework that you've heard about today, proposed by the companies to develop and administer future competitive procurement programs, is reasonable and complies with South Carolina law, section 584120E2, and this Commission's order 2022-482. And second, the 2022 Post-Independent Evaluator Report adequately demonstrated the proposed RFP framework can result in a fair, transparent, open, and non-discriminatory competitive procurement process. The comprehensive settlement agreement reached by all parties settles the issues identified in the dockets and is in the public interest, as the agreement recognizes the efficiency of using the company's existing single system-wide procurement framework and processes for the procurement of energy and capacity from renewable resources within the company's balancing authority area. The framework also incorporates the best practices of competitive procurement, which includes stakeholder engagement, independent oversight, a robust bid evaluation process, cost control mechanisms, alignment to the approved interconnection processes, and finally, guidance related to transmission-constrained locations on the company's grid to assist the market participants. The framework is reasonable and complies with South Carolina law and the Commission order. The agreement acknowledges that the company's CPRE procurement must be driven by the resource needs identified by an IRP or other planning process, and it is appropriate for the companies to be afforded the flexibility to identify renewable resource needs and the timing of such to efficiently manage any procurement on an ongoing basis. In addition, the Comprehensive Settlement Agreement recognizes that the 2022 RFP is a reasonable step for the companies to take towards procuring renewable generation. The Comprehensive Settlement Agreement also affirms important customer protections inherent in the standard rate-making process that, one, serve to mitigate certain risks associated with development, acquisition, and construction of solar projects, two, incentivize the companies to efficiently manage the procurements and govern their spending, and three, allow for a complete review of the project activities, costs, and benefits after the renewable resources are placed into service and generating electricity. The customer protections included in the Comprehensive Settlement Agreement preserve the ability of ORS and other parties to conduct a full historic review of the known and measurable costs and investments resulting from the 2022 RFP in a future appropriate cost recovery proceeding, and make recommendations to this Commission as to what costs, if any, should be recovered through customer rates. Likewise, the Comprehensive Settlement Agreement preserves the Commission's authority to determine what costs the companies are allowed to recover, how those costs should be recovered, and when they should be recovered through customer rates. The Comprehensive Settlement Agreement works to minimize the risk to customers while remaining supportive of the customer's desire for ongoing investments by the company to provide reliable and high-quality electric service. Moreover, the Comprehensive Settlement Agreement saves the time and cost of a fully litigated hearing before the Commission and any ensuing appeals. Therefore, ORS respectfully requests that the Commission approve the Comprehensive Settlement Agreement, and we appreciate your time and indulgence in adjusting the hearing times to consider the settlement agreement. Thank you.
Thank you, Ms. Hipp. Madam Chair, Ms. Hipp is available for Commissioner questions.
Thank you, Mr. Weston. Commissioner Justin Williams.
Thank you, Madam Chair. Good afternoon, Ms. Hipp. How are you today?
I'm good.
Quick question for you. Do you have any opinion as to whether or not the program as presented increases reliability in the utilities territory?
Well, I always have lots of opinions. On this topic, you know, the company's 2022 IRP update and the subsequent 2023 IRP, which will be reviewed by the Commission in the coming year, identify the need to add solar. And solar is part of a diverse portfolio. ORS is fuel agnostic. We are looking for the most economic and reliable fuel resource to provide to customers. And in that vein, the 2022 RFP and the framework that the company has put forward will rely on the IRPs and therefore increase fuel diversity.
Thank you, ma'am. Do you have any concerns that their program may undermine or hinder reliability?
The framework for the procurement does not appear to hinder the procurement of reliable energy products.
Thank you. Thank you, Madam Chair.
Thank you, Commissioner. Vice Chair Powers?
Thank you, Madam Chair. Ms. Hipp, good afternoon.
Good afternoon.
One of the big objections that ORS had early on or in their preparation appears to be the whether or not this is in the public interest of the ratepayers of South Carolina, taxpayers of South Carolina. And that obviously was conceded in the settlement agreement. Can you explain how that particular thing was reached between the parties or satisfies ORS's concerns?
I think to look at the settlement closely indicates that the ORS and the parties have agreed that the RFP framework, which are general elements of an RFP, a future RFP, if you will, are in the public interest. So those general items such as stakeholder engagement, reliance upon the IRP to determine the need, those types of things are in the public interest. Where we differed from the companies in our rounds of testimony, which have been resolved here in the settlement agreement, is the fact that ORS believes that the 2022 RFP and the rate-making treatment requested by the company may not be in the South Carolina customers' public interest. We differed on that point. We have resolved it here in the settlement agreement to the comfort of ORS to allow us to review all of the aspects after the company procures, builds, the energy resources are in service for the customers, and we're in the appropriate rate proceeding to review those things, such as should it be allocated to South Carolina customers? How much should be allocated? How much should have been purchased? And then, of course, the prudency to develop any of those development activities. So we are comfortable that the settlement agreement secures standard rate-making treatment for any asset that the company chooses to procure in the 2022 RFP.
So you feel like South Carolina's not giving up any concessions in this, and that ORS will be able to monitor, and this will be looked at in a rate case?
Yes, and in a fuel case. So we feel comfortable that the settlement agreement reached by the parties preserves the Commission's authority to look at the development of solar resources, whether it's a 2022 RFP, you've heard about the 2023, now we're hearing about a 2024 potentially. You'll be able to look at the 2022 in the confines of your rate-making processes, fuel or general rates.
Okay. And are you comfortable that in entering this agreement that the Commission or South Carolina is not violating any constitutional issues that were raised as far as, we're not following North Carolina law in any way?
You are correct. We are not following North Carolina law. Okay. So North Carolina laws are embedded in the 2022 RFP, which is why you saw the company and ORS taking differing positions on that. The settlement agreement does not put the Commission in the position, if the Commission were to approve the settlement agreement, to inadvertently approve of the rate-making treatment, the ownership percentage that you've heard about for solar. The settlement agreement would not put the Commission in the position that is being approved today upon approval of the settlement agreement.
Okay, well, it's none of this is easy, but it's particularly not easy as far as a company that crosses state lines, and we deeply appreciate the understanding that ORS brings to this procedure and to all of our work and things that beyond our scope that y'all apparently have worked on and have done. Thank you.
Thank you.
Commissioners, further questions for the witness? Commissioner Karen Lee Williams.
Thank you, Chair Belser. Good afternoon.
Good afternoon.
I think I'll start with a question about how we plan for and learn from the experience we've had to date what is ORS's position on kind of how we move forward, the idea of the docket, taking stakeholder advice, taking lessons learned from ORS and from the company? Any comments? You've heard those questions earlier.
Yeah, moving forward out of this experience, one thing occurs to me is that the company does, the framework that we have outlined in the comprehensive settlement outlines what the company has done. They've done it for several years. They do it very well to take stakeholder engagement prior to the final design of the RFP, have independent oversight in one form or another. I think that the framework provides enough guidance to the company such that it also retains the flexibility to determine, based on ongoing circumstances, things change in the energy industry, and to have an overly prescriptive process outside of the framework could hinder the company's ability to adapt to those conditions. And when you have those types of barriers in your way as a company, sometimes that results in higher cost. So ORS finds that a general framework as outlined in the settlement agreement is sufficient. We do appreciate having the information that flows from the company to the commission in a docket, where they're at within the RFP framework, whether or not they have made awards, what they are doing next, to be very helpful. But beyond that, it is not our position that the commission should be approving on the front end the RFP format. That would, to us, limit the flexibility of the company to adapt to emerging conditions.
My sense from answers to that question earlier was that there are going to be some lessons learned about the differences of opinion that you all have had, and that we may have new information, new lessons learned that evolve after a field case or after a rate case. Would that be a better time to have a conversation about whether this is the best process, or if I understood you right, you feel like the framework's in place and we don't really need new testimony, new decision-making about how to improve the process?
Right. The RFP framework is broad enough to allow the company's management to make decisions in the interest of their customers to procure generation, whether it be solar, as we're talking about here, or other types of generation. That is sufficient from the ORS perspective to provide guidance to the company. The difference of opinion as to the rate-making treatment and the approval of any specific target volume of solar, state allocation, utility ownership percentage, which is what the company had asked for when it asked for the 2022 RFP to be approved, is not something that ORS believes that, number one, it can't be verified. So ORS is very uncomfortable with being asked to verify benefits that are not quantified and costs that are estimated. So to do that prior to those energy resources being in service to customers is difficult, and we don't find that to be necessary.
You may have totally understood my question, and I'm going to make sure that we're connecting on this. I really was asking not about this particular request, but the idea that CPRE processes can be improved over time, and that there was a request in Witness Smith's testimony that we consider opening a docket for more of a impact on perhaps the 2024 RFP. Is that, were you answering a question related to that, or were you answering a question related, was I totally unclear?
It is not clear to me what that request of the company is designed to elicit as an action of the commission. So the RFP framework that the company has put forward is detailed and contains the flexibility that the company will need to act in a prudent manner in the best interests of South Carolina customers. If something in that framework needs to be adjusted, maybe another element needs to be added based on some sort of experience that the company has had as it goes through the procurement process and awards bids and develops projects with third parties or self-develops, then certainly I would imagine if the commission approved the RFP framework today and we needed to add an additional 9th element or a 10th element, then that would be something that the commission should have a docket to take a look at.
Okay. Thank you very much. I appreciate the answers.
Thank you.
Commissioners, Commissioner Thomas?
Thank you. Good afternoon.
Good afternoon.
I think you have pretty much already answered my question, but I wanted to try to put it out there in a manner where maybe it could just be a yes or no answer. So my question is, do you believe that this settlement agreement provides ORS with all of the tools and options that it needs in order to determine that these programs are in the best interest of South Carolina customers on a go-forward basis?
Yes. May I caveat?
Sure.
May I add to that?
Yes.
The settlement agreement provides sufficient protections such that ORS will be able to evaluate the costs and project activities of the company in the appropriate rate proceeding, whether that be fuel or a general rate case. So, yes.
All right. Thank you.
Thank you.
Commissioners, anything further for this witness? Hearing nothing, Mr. Mustian, any redirect?
No redirect.
Thank you. Ms. Hipp, thank you for your testimony and your appearance today. We appreciate your testimony, and you may stand down. Thank you.
Thank you.
Mr. Mustian, anything further?
Nothing further.
Mr. Welborn? Anything further?
No, Madam Chair, thank you.
Mr. Witt?
Nothing further.
I know we have some council virtual. I expect that they would get my attention if they needed to. Proposed orders in this matter, do you have any insight on that? And I'll just tell you, I asked Mr. Stark, our staff counsel, Mr. Stark, to send that email yesterday because we do have virtual parties or counsel for parties, and it's just difficult to talk to the ones in the room and the ones that are virtual. So I just ask that y'all confer on that before today and give us an answer.
Yes, Madam Chair, we have conferred, and I believe we have alignment on January 12th as a proposed date for a proposed order.
Okay. Thank you very much. Is there anything else that needs to come before the commission with regard to this docket? Or these dockets? Okay. As always, I'd like to thank all the parties for the presentations. As always, I certainly appreciate the professionalism from the attorneys and the witnesses. Y'all do an excellent job in your presentations, and we certainly appreciate that, and thank you very much. And with that, we will close this hearing and notify y'all of our decision at an upcoming business meeting following receipt of proposed orders. Thank you very much. Have a good day, safe travels, and if I don't see you before Christmas, Merry Christmas. Thank you. Bye-bye.